All right, peace, everyone. Welcome to the Moroccan Post School of Government and International Law. All right, this is our Moorish Treaty Protection and Consular Relations course. This is 201. All right, we finished up the Moroccan Moorish Treaty Protection and Consular Relations course 101 with 9 sessions. We began on November 30th, the 201 session of the Moroccan Moorish Treaty Protection and Consular Relations course. All right, this is part 2 of Writ of Quo Warranto. November 30th was our last class. All right, so we have our YouTube. Let's go back. So we have my books, Moors and Masonry. Go to the moorsandmasonry.org, Moors and Masonry, part 1. The Illuminati and Illumination of the Mind, the Masonic Compass and Square, and the connection of measurement and timekeeping, the how her Venus and Moon rule, etymology and vocabulary is something that you want. Coming your way, February 2023, Moors and Masonry Part 2, the power of Moorish treaties and the recovery of lost Moorish sovereignty, moorsandmasonry.org. All right, we have our YouTube channel, the Moroccan Post Media YouTube page. Moroccan Post Media YouTube page. Our classes are uploaded. These classes are free. What we're starting or will have available in February, along with my Moors and Masonry Part 2, we'll have the first of the study manuals. The Moroccan Post School of Governments and International Law series of study manuals. All right, we'll have the first one available. The books will be sold for $25. All right, that's coming your way. So we're working on a series of study manuals that will complement the course, the courses. All right, next we have and then we'll go right to the all right. So yeah, so we have this is part 2 of the Writ of Quo Warranto. Writ of Quo Warranto part 2, the Moroccan Post School of Government and International Law will present Shem Malachi Bey, Moorish Treaty Protection and Consular Relations, Writ of Quo Warranto Part 2. Our classes are Wednesday, December 28th. The next class will be in 2 weeks. The second Wednesday of January will be our next class. Second Wednesday in January, whatever date that is, please someone give me that date. Second Wednesday in January, 7 p.m. to 10 p.m. Eastern Standard Time is our next class. And we'll go with part 2, part 3, because we're gonna have a sample of a Writ of Quo Warranto for the next class. All right. Then we have the next screen. Now we go right to the, all right, good. So we're starting, this is where we ended. We're going to start here. This is consular jurisdiction. Let me explain. All right, so we're going to go, we start here, consular jurisdiction. Maybe we have a reader. We have a reader.
Yes. Consular jurisdiction. When the treaty stipulates that a consul from each nation or jurisdiction is the only judicial officer that can make an adjudicated decision based on the civil or criminal dispute between the two citizens of different nations. 2, when a consul, public minister of each nation is being hindered and prevented from enforcing the treaty by the state of origin, she or he has the right to file any writ that shall assist she or he in enforcing the treaty in either jurisdiction of the high contracting parties in unity with the de jure Constitution of the de jure United States of North America. 3, the de jure United States Constitution, the treaty contract alliance among the states, delegated authority to its Supreme Court to hear treaty claims without filing any pleading in the lower district court of the Federal Appeal Court. Important notes about the power of our Moorish treaties. 1, Moors cannot use the United States Constitution in place of the Moorish treaties. Number 2, Moors have to look within the Moorish treaties to enforce your rights and claims. Number 3, the United States Constitution is the legitimate document that says that treaties are the supreme law of the land.
Let me stop you here. This is, we did do this last week, so this will be a great review to segue way into part 2. All right, Shem, you want to elaborate? This is just to be review from the November 30th class, which was just part with Quo Warranto part 1.
Yes. If an office is not delegated by the under constitutional authority, meaning that the government, the people, the Constitution, the nation is mothered by the Constitution. The voters are the ones that delegate these offices. Whoever delegated to the executive, legislative, and judiciary branch, that's the only authority they have. Now, that branch of government create agencies and organizations and units. Whoever's not delegated to them, they don't have power to operate in that capacity. Like, for instance, if the courts have a judiciary act, no court can hear a matter unless dealing with a foreign national, unless that nation entered into a treaty, a binding agreement, where though it waived the constitution of both nations, allow the treaty to become the legislative power to regulate commerce and activities between the two nations. So when you sign a treaty, by giving another officer the power in the treaty to legislate or to hear disputes among civil and criminal disputes among each other, is a political power. Therefore, each nation waived the right to their constitutional operating as the control authority dealing with both nationals. Let me say this: a citizen and a national, a citizen of a government and a foreign national. That means that if a foreign national is in a foreign country, a foreign jurisdiction, or territory, or region, or district, if that court or judge is not delegated authority to hear foreign matters, then the judge cannot hear that matter. The judge is res judicata. The judge is blocked. There's a bar against the judge from hearing that. The judge has to dismiss the claim for lack of jurisdiction. I mean, I can't hear it. Why? Because the judge don't have status over the foreign national. The foreign national is not an immigrant, and the foreign national is not a citizen of the state. So therefore, it deprives the judge of the power to hear, because judge can only hear disputes of citizens with disputes between one another, or the government agency that delegate authority by that government. That's it. Outside of that, you can't do nothing. They can't hear no foreign claims at all.
Questions, anyone? Any questions? Any questions? This is important to understand the basis of the writ of Quo Warranto. This is what we're laying down. Yes. Any questions?
Yes, the question is if you send out a writ and they refuse to recognize your writ, what is the ratification of that?
Well,
the ratification.
Hold on, Shem. Hold on, Shem. She says she didn't say a consul. She said if you. I don't know what the you is. Who? All right. Hold on. I want to know what the you denotes. Because she said you. So let's
as a national.
All right, but
as a Moorish.
Yeah, but that's still not a position though. A national is not a position, an office.
Okay.
And this is for learning. This is for learning purpose.
That's why I asked.
A national is not a position. That's not a name. That's not a name of an office. That's not a name of an office. National. So who will be sending the writ out?
The council.
See, that's why I stopped. That's why I said, that's why I
I
stopped.
got you. It has to be under the consul. So if you send a writ out even under the consul,
Why a consul? This is why
because
we're gonna slow this down. We're gonna slow this down. Why a consul?
because
Why
as a
why not a just a national who's not a consul? Why a consul?
I don't know, explain that.
All right.
I think I have the answer. I'm not sure. I don't.
All right.
So
What
let
do,
me
what do
hear
you
it.
think the answer is? What do you think the answer is?
Because as Moors, we are under consulate. So I would assume we have to be part of the consul as a delegated authority over, well, let me hear your explanation. Let me stop
All right,
there.
Shem, go ahead.
Yes. Like I said before, the treaty, when both nations sign a treaty, their constitutions become is not enforceable. I mean, against either one of them, each of them. I mean, the national or the citizen can be tried in each other court. Therefore, they appoint in the treaty a council, which is a judicial officer to hear all political, foreign, civil, and criminal disputes between both the citizen of that state, the hosting state, and the citizen of the receiving state. Therefore, that the treaty becomes the lawful binding instrument. The treaty articles of the treaty operate as if it was a constitution that reference to that both nations that set up dispute. For instance, say if a national is from a foreign country and national do some he's a foreign national and he do something in the political jurisdiction of a hosting nation. Now, the laws of that nation does not apply to that national based on the treaty, because it's a dispute now. The judicial officer is the one hears the matter. So therefore, when the matter is being heard, all the testimony and evidence and the letter of rogatory goes before the council. The judge of the court of a local domestic court can't hear the matter because the judge is not delegated authority pursuant to the treaty. So the judge can't hear the matter, can't rule on the matter, can't speak on the matter. So therefore, it'd be frivolous and fruitless for a national to file a writ before a court that don't have power or authority to hear that writ. A council, that writ can be filed before the council, who can enforce that writ through a proper channels of government relationship, diplomatic channels. Through a letter of rogatory, he can ask for the witnesses to appear. He can order testimony, transcripts, stenographers. He can weigh the evidence and make a judicial decision based on the national law that protects that national or the citizen of that state. And whatever he decides becomes a ruling decision through the agencies that's set up by both governments to operate to hear that dispute. So if you take a writ before a judge, and let's say a judge grants a writ, but the judge don't have power to hear that writ, any attorney general of the state can have that go for any authority and have that writ overturned or reversed because the court had the power to hear that writ. I mean, the judge had the power to speak on the matter. There's already self-determined to a self-executed treaty. Everything's already determined how it's going to play out, a criminal dispute, everything. The treaty becomes like that constitutional agreement now. It supersedes everything now, the treaty. That's why I say the treaty is the law of the land, every state. Judges are bound. What you mean? Judges are bound to what? Stay out of the business. They are not delegated authority to hear any kind of foreign matters. All you got to do is read the Judge Act that created the courts and the judiciary and the judges, and read the act. With the act of legislature stayed by act of the Constitution, it gives them a right to hear foreign matters. And if that's true, then the act will be in that treaty. It would delegate power to that court. I mean, the other government said, yes, we agree that if any dispute happens, criminal, civil, or political, it'll be heard before your tribunal. It will be in the treaty, because it's not in the treaty, it's a council that's a foreign judicial officer representing the nation for their nationals. Therefore, the treaty that written you will file become de facto. I mean, it's no good. The judge didn't have a right. The judge didn't have a right to speak from the beginning. They really get the matter because you're not property of the state. the courts don't have jurisdiction over you because you're not a subject of that government as a citizen. You understand?
Islam, just asking. I appreciate
Yes.
that, Islam.
Yes. Any questions? Any more
No.
questions?
Any other questions? Any other questions?
No.
Any other questions? This is important. This is why we're taking our time. All right. This is a very key area right here. Because of the misconceptions taught by, not Albions, taught by conscious Moors. Because of the misconceptions taught by conscious Moors, and I was one of them. Because of the misconceptions taught by conscious Moors. This is why we got to take our time, because we were taught that we're part and parcel of this set of government. Enforce the Constitution, enforce the Constitution, enforce the Constitution, enforce the Constitution. We the people of the United States, that's the Moors. Moors, 35 Moors were at the United States Constitutional Convention. Because of the misconceptions, Moors are the founders of this government. Because of the misconceptions, we gotta continue to review, and take our time. Make sure that we're solid. This is solid on this. And the misconceptions are still out there. Conscious Moors are still teaching the misconceptions. All right, so we're battling with conscious Moors. We're battling with conscious Moors. We're still teaching the misconceptions. Not the Albions. Albions are not teaching this misconception. Albions have never taught that Moors are founder of this United States.
Okay.
Albions have never taught that 35 Moors. So I'm not saying conscious Moors have taught that.
Yeah.
All right.
Sanchez Llamas, the court's authority to create a judicial remedy applicable in state court must therefore lie, if anywhere, in the treaty itself.
Hold on. Give me a minute. Hold on.
Where a treaty provides for a particular judicial remedy, courts must apply it as a requirement of federal law. United States versus Giordano. Res judicata. Before the
Shem,
court
put your
can
phone on
consider
mute.
anything,
Shem, hold on, Amanda. Shem, mute your phone. Yes, go ahead.
res judicata, before the court can consider anything, it must first look to that which has already been decided. The case cannot be litigated when the issue has already been decided in previous case or cases. The treaties are the supreme law of the land. The treaties are the standing decisions. Moors must stand on the principles of the treaties. When you file a writ of quo warranto, anything that is done prior to the filing is void because the authority rendering the decision never had the authority in the first place, based on the treaty. Those who are usurping authority in a de facto capacity cannot ask the court to do something because it is res judicata. The treaty speaks for herself. Judges have no rule based on the merit of the treaty. The judgment is void.
All right, any questions? That was review from the last class, which was November 30th. And just we wanted to review that point. Shem broke in the part one. Shem gave a very extensive explanation of res judicata and collateral estoppel. So I would advise you to listen to part one for he spent about, about 20 minutes. He spent about 30 minutes on res judicata and collateral estoppel. He really did. He gave a very thorough explanation of both terms.
And also going back through the previous classes and some of the cases, you see that principle in some of those cases that we had discussed previously, like Hausenstein versus Lynham, for instance. And
Yes.
so you can see some of those in there.
Class
as well.
1 and 2. Yeah, that was the first week. That was August 24th and August 30th. Yes, yes, that was in the 201 course. Absolutely, very, very. We'll talk extensively about, you know, treaty protection, and then also we read excerpts at the when Shem got off. I think it was 3 or 4 consecutive weeks classes where we would just read excerpts of the counter memorial, United States counter memorial to France in 1952 case, where dealt with excerpts of various extraterritorial capitulatory clauses, and was mentioned only a consul, only a Dutch consul, only a Danish consul, and it was
So you see it
very
tied into
specific.
all of that.
Yes, it tied it all in.
Procedure and methods for filing a writ of quo warranto for an individual Moor. The execution of the writ of quo warranto. Moors in government structure and function. A Moor contacts a Moorish sheikh or Moorish consul to construct a writ of quo warranto. A Moorish government, through a Moorish consul, can issue a letter of rogatory to the United States Attorney General or District Court for judicial assistance to have the case be heard by the Moorish government. The writ of quo warranto can be enforced by a Moorish consul and or sheikh. The sheikh or Moorish consul sends a letter of rogatory for judicial assistance to the Attorney General or Federal District Court in the appropriate district. Note, the state's attorney generals have to prove that they are authorized by treaty based on the plain language in the treaty. The only thing the state's attorney general can consider in a quo warranto matter is the treaty. Approach the attorney generals of the states as a political body through a letter of rogatory concerning the captured or imprisoned Moors' status being ignored. An example of the language used in the letter of rogatory. You have Moors in your prison who were not given proper jurisprudence as British subjects and given protection rendered under the Treaty of Amity, Navigation, and Commerce of 1795, the Jay Treaty, the Treaty of Peace and Amity of 1814, the Ghent Treaty, and Moorish treaties. The Moors were not given the opportunity to nationalize. Note, if the attorney generals of the states deny the letter of rogatory, bring them up on international charges for human trafficking.
All right, let me stop there. That conscious Moors have been teaching conscious Moors, and I was one of them, to ask for a delegation of authority order, you know, and that is improper. Why would it be improper for Moors to ask a United States Attorney General or a county sheriff or any state official belonging that is in a union to the United States for a delegation of authority order? You're not a citizen of the United States. So if they have a delegation of authority, all right, you ask for a delegation of authority. They have a delegation of authority. They show you. You're not a citizen. You're not, they're not a Moorish consul. A delegation of authority order for what? A delegation of authority that you're not a citizen of that government.
Absolutely.
They're not your official. So whether they have authority or not, if they had authority to operate in that seat, they're not your official though. They're not your official. I mean, I'm doing this because conscious Moors, and I was one of them, has been teaching us. So we you know, this is a paradigm shift. This is a paradigm shift, and this is why we're spending a lot of time on treaty, you know, international law. You know, this had not been part of the studies. Any questions? And I will
Islam.
continue. Yes.
Okay, so you're saying that you can't ask for a delegation of authority letter to see if to give them authority to override the Vienna Convention on treaty laws or anything?
I didn't say
You
that. No,
can't.
I didn't say that.
Oh,
No,
okay.
I didn't say that. No, say what I said. No, I
No,
didn't
I know.
say
I'm asking a question.
All right,
I'm
then
asking.
say that.
I didn't make it a
I
statement.
thought you said
I'm
I
saying.
said it. I didn't say that. I know.
Well, I was trying to get I was trying to get an understanding with the question.
Go ahead.
Okay. Yeah. Like if they're violating a treaty article, can't you say, hey, do you have a delegation of authority to override the Vienna Convention or to override the UN charter on treaties? Can't you ask for delegation authority right then? Because if they're violating
No,
the
I'm not.
treaty,
All right. No,
violating international convention.
all right.
Okay.
Let me say this, brother. Let me say this. Conscious Moors have taught conscious Moors to ask for delegation of authority order from a sheriff, from state officials, from the judge's oath of office, from the state attorney generals, delegation authority order. They're not asking them for delegation authority about treaties, about constitution. Conscious Moors have been, let's stay on what conscious Moors have been taught, teaching. My statement, all right, that's Murray Bay. The context in which I said it. Hey, this is for everybody. This is for everybody. You have to analyze the context in which I made the statement. Once you take what I said out of context and then place it somewhere else, you change the meaning. Analyze what I said in the context in which I said it. The context in which I made my statement is that conscious Moors, and I was one of them, have been teaching other conscious Moors to ask for a delegation authority order for the oath of office, delegation authority order for state officials, federal officials. And I made the point, we're not citizens. If they asking for a delegation authority order to operate in that capacity as a state judge or a state senator or federal senator, they're asking them for a delegation of authority order do you have a delegation authority order to operate as a sheriff? You have a delegation authority order to operate as a state attorney general? You have a delegation authority order to operate as any state official? That's the context in which I said it. Conscious Moors are taught that ask them for a delegation authority order to operate in the capacity in which they claim to operate. Conscious Moors are not taught anything about treaty relative to, though they have authority to that's called a treaty. Conscious Moors are taught to ask the United States or any state officials, do they have authority to operate in said capacity as state official, state attorney general, sheriff, cop, you name it. That's the context in which it's taught. Let's analyze that. Analyze that context. Let's not take it somewhere else. That's the context. Conscious Moors are not taught to ask United States officials or any state officials, do they have authority order to execute a treaty? Conscious Moors aren't taught to do that. They ask them do they have a delegation authority to operate in your said capacity as a sheriff, as a judge, as a state senator, as a federal senator, as a federal House of Representatives. And I'm saying that is improper because we're not United States citizens. They're not our officials. So whether they have authority, or not to operate in as a state official, as a state judge, as a congressman or woman, it's irrelevant to us because we're not United States citizens. That's only relevant to a United States citizen. The issue with us relative to consul jurisdiction, where the writ of Quo Warranto is protecting the authority that the Moorish consul has, that delegated to a Moorish consul by treaty. The states are usurping that power. They're usurping the power of a Moorish consul. State prosecutors, state district attorneys are usurping the power of a Moorish consul, because only a Moorish consul has the power to deal with disputes when a Moor is a defendant. So that's where the writ of Quo Warranto comes in, is to, by what authority do you have to exercise the power of a Moorish consul? As that authority is delegated to a Moorish consul by virtue of a Moorish bilateral treaty with the United States. I want to make sure my point is very, very clear. I don't want my point to be going somewhere else, taking out of context. I taught this for 25 years. I taught that misconception for 25 years. I know it well. I know misconceptions very, 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 very well. Shem?
Yes, absolutely. That's right. You tell the truth. Nobody has a right. For instance, let me lay it down this way. How can one be a president of the United States or governor unless they're elected? In order to become a governor of the state, you got to be elected. They say you're a governor going to sit in that seat. That's not lawful. That's de facto. It's illegitimate because there's no election. The Constitution states lays down the power of a governor to hold that seat, a man or woman to hold that seat. It's said through elections. So if a judge is delegated authority through his own act of his legislators of a government, and the act does not give the judge power to hear foreign matters based on the treaty, hear the language. The language is everything. Please hear me good. If it does not give the judge power to litigate matters of that country or nation with a foreign nation pursuant to a treaty on treaty rights, the judge does not have delegation authority to hear that matter. Then after that happens, when a treaty is signed between both parties, the other party got to consent to that. But once they say a council, once the word council come in there, it strips the judge of the power to speak now, based on the subject of the vessel, the body. The subject matter is the vessel. The courts can't control it because it's not a subject of the government. It's not a citizen of the government. So
Shem,
therefore, yes.
we want to make it very clear, more what you're teaching, conscious Moors aren't being taught. Conscious Moors don't teach what you're teaching. I didn't teach what you just said, Shem. I didn't teach that for 25 years. What you just said. What is taught is to ask for a delegation of authority order to see whether the judge is an actual judge, a United States judge, that see whether or not, it has nothing to do with the judge having power to hear treaties. That's not why conscious Moors are not instructed the way Shem is teaching. Conscious Moors are taught, I want to be very clear, to merely ask whether that state official was duly appointed or elected as a state official, whether the issue of treaty doesn't come up, not whether they have a power to hear treaties. That's not the issue. The issue that's raised is whether, for instance, I mean, you get stopped. This was, I taught this for 25 years. Conscious Moors are taught by other conscious Moors. I got to stay on the misconceptions. Conscious Moors are taught by other conscious Moors that ask for the captain, that ask for the captain. Come on now, hear me out. Y'all know what I'm talking about. They ask, why you want to ask for the captain? Conscious Moors are not taught by conscious Moors to ask for consular notification. Consular notification was not taught. That's something that Shem brought to the table. It was asked for a captain or a sheriff, a county sheriff, to come to the scene, as if that's your official, as if you are a citizen of the state. You're asking, that's what's taught. I know the misconceptions very well. Believe me, I've taught them. I've been in presence with many heavy hitters. So-called heavy hitters taught this. Go ahead, Shem.
Yes, absolutely. The problem is this way. See, what's going on around us every day is everybody running the government around us, we're not paying attention. The school system is set with a structure: a school superintendent, a mayor, city council, a commissioner of commerce, a president of commerce, a president of city council. See, all this stuff is already being done around us, and this is how government is ran. So when it comes down to us, the first thing is self-determined among ourselves. Once we do that, we're not considered as property of the state anymore or subject to the state. I mean, the state can speak on behalf of us, our bodies, our consequentity. See, your consequentity is your body. It's your title, your body. They want a title to your body because you are a piece of real estate come from the earth, your mother. They want real estate, they want title to your body. So if the state got title to your body, certificate of your consequentity, mean your consequentity is lost, mean it's not a claim through a government structure. Therefore, the state got power to speak because they hold what? They hold you as collateral, you commodity. Now, when you come from the government on the nationality, consequentity, that right is protected now. You're not property of the state. You're not cattle. You're not a title or charter property. That means now you claim your nationality to a consequentity. You mean have the same. You have what you call certain claims under the law of the land, not as property. As a foreigner, you are considered a lowly entitled to the land. I mean, your mother, father come from the land, and you are the goods of the land of this nation. Now, what happens is the judge can't speak. Why? Because the judge was not delegated authority in the treaty or in the own constitution or act of the legislature to hear foreign matters dealing with treaty matters between two nations. So that cuts it out, de facto. No authority. See, we got to go by what's written. Everything that's done in contract is written. A treaty is written. The treaties are considered itself as agreement as the constitution that regulate commerce, economics, everything between these two nations. Without that treaty, the nation can't have no agreement. Neither one can do business together. So when they know they're doing business, one is on another one's soil or political jurisdiction, so they hire to give somebody the power to hear the matter if it is a dispute, civil or criminal. That falls under political power. Who got the political power to hear this matter? The receiving nation. What you mean? When a hosting nation say that a citizen of their nation get to speak with their foreign nation, the foreign nation have a right to be protected under the receiving nation constitution as if they was their own citizens, and have the right to be assisted, and have the right to all the equal protection afforded in that constitution as if they were a citizen of their land and political jurisdiction. Yeah, but without that language in the treaty, it said council have the matter. When you say council, let me explain something. You mean that anything decided, anything heard of, is heard of and decided by that council. See, let me tell you something. They don't even teach you the political science. You know why? because it would strip it opened up a lot of fraud, can of fraud. What you mean? See, the Supreme Court made it clear they cannot hear a matter if that institution is not constitutionally what? If it's not constitutionally erected or created by the legislators. So therefore, what the legislators consent to and ratify with a foreign nation, if it ratified a foreign tribunal, a foreign officer, judicial officer, that's who have power to make decisions. Therefore, if that council make a decision, it can't be appealed to by that foreign court. Because the council make the final word, it's over. If there's a problem with it, you gotta go to the International Court for disputes. International Court of Disputes. The Hague is made up of two divisions. International arbitration, international disputes. When disputes arise over territory or commerce, they have international chamber of commerce. When we talk about jurisdiction and territory, we have international arbitration. We got disputes between nations not honoring treaties, the international settlements of disputes. It's very important. We gotta know this. It's my whole that seat. So even the jurors, a lot of jurors are being stripped of this knowledge. Why? Because they know they can't perpetrate a fraud on them either. The bottom line is why ask yourself a question. Why do they agree for a council to represent their nation? If the council is defending his nation, he's the only one that make the laws. Or the testimony. Who will make the determination? The council. That's why they got council jurisdiction. What happened was, when the United States government did, and also Europe did, Europe created what you call a Ministry of European Affairs for each nation. It's the Minister of European Affairs. The United States created a central authority. They didn't want to hear all international agreements and treaties, conventions, declarations. The council holds jurisdiction in a political jurisdiction house. The house got immunity from prosecution, its officials, its cabinet, its office, everything. They got subpoena power. Now, when a matter happened, the council goes before the central authority and say, hey, wait, we got a problem here. We're not national to speak with a citizen or agency of your government. Therefore, we're going to set the matter through. I'm going to hear the matter based on a treaty. It gives me a lawful authority. The central authority, through the central authority, you issue a letter of rogatory. The first thing happened, the council go to the federal courts under their laws and say, wait a minute. You got the State Department got a federal magistrate that gave an international number to remove the case. What the council do is remove the case out of the state, file a petition in that council jurisdiction to have it removed. The magistrate, the delegate authority by the State Department, Department of International Defense gives a docket number. It goes to the state political jurisdiction and deposit that notice into the state and say it's removed. To where? Now, once the number gets there, now what the government does, the council does, is the council move into the court based on treaty, the Mufti court, was the political court of the Moors. Once it gets moved to the Moors court, now the Moors council issues called writs of Quo Warranto, writs of mandamus, writs of Quo Warranto, habeas corpus. When they don't answer, what the council does is do a writ of assistance. Put the council seal on the default of the writ and do a writ of assistance to the Supreme Court. So wait a minute, we got in their constitution, it states that when something affecting a public minister or a diplomatic or council, the Supreme Court got original jurisdiction. That means the high court. You go to the retaliatory office of the Supreme Court, file a writ of assistance, and test the default order of the writ, and say I need the writ enforced. Based on the treaty, the Supreme Court got to enforce that writ. That's how it be done. That's the proper way to do it. Any more questions? Any questions?
Any questions? We got questions. We got these questions. Yes, there are questions.
Islam, could you repeat that last part?
Repeat that last part, Shem.
When the council,
I know he can.
When the council goes to see, this is happening. This is why you got to be well schooled in law, diplomatic law, and foreign law. See, the international, the State Department got a Department of International Affairs. What happens is they got a federal magistrate that sits there. That any foreign matters come dealing with a treaty or international conventions or international law, that magistrates and one get the petition and notice based on CFR and based on federal statutes on the CFR regulations. What the magistrates do, issue a number, so the matter is an international matter. What happens is now the council takes that matter, do what you call a petition, and remove it to his court based on a treaty claim. And then he serves, take that notice of removal for that federal jurisdiction of court that gave that number. So it's not gonna be heard by any federal magistrate or any federal judge. It's heard by the council or the mufti based on the treaty. And any political jurisdiction, remember what? The crown. Now what happens is now, because the states are formed or operating as a corporation governments inside British territory, which is called the colonies, therefore the council got jurisdiction, the mufti got power in a British colony to hear that matter. He be moved to the mufti court, and now all the letter rogatories, maybe they go from the mufti court to the central authority to handle everything from there. That's the end of it. It's all over. What you're doing is now, you protect all the Moors now. Now the Moors are protected. All the nationals that claim nationality, claim to be one to be separated from the corrupt government, is protected now. Under what? Under consequency, under international law, you're protected. Under treaty law. See, in order for us to get protected, we got first come together and assemble. And we got to stop trying to go to, for instance, Japan. If Japan got a treaty with the United States, Japanese live right here in the United States. Believe me, if the Japanese got a problem, they're gonna go to the Japanese embassy first. Ask for the council.
You know what it is, Shem? What will bring us together, Shem, is what we're doing now, Shem. Shem, without proper instruction, Shem, we're doing it. Proper instruction. This is, remember, it's been over 29 years for me. And I was the victim of 25 years of misconceptions. I've seen a lot of people come through. The proper guidance and proper instructions will bring us together. I don't see no other way. I don't see, without proper guidance and proper instructions, we're not coming together. No instrument is it's proper guidance and proper teachings that's doing it. We're doing it, but it's gonna take some time, yes. But proper guidance. The misconceptions divide us. It's the misconceptions that unconscious Moors have, the misconceptions that conscious Moors have. So you got misconceptions that conscious Moors have been teaching misconceptions to conscious Moors. Then you have unconscious Moors that's still in the black. So you have unconscious Moors that teaching black. They have conscious Moors that's teaching misconceptions too. So what brings us together is clarity. Because of the misconceptions, man, that fractionalizes us. This is why we established the school. This is why we have these classes. This is why we made the classes free. It's getting out, but it's gonna take some time. You have people on here, Shem, that was riddled with misconceptions that they have developed over the past 4 or 5 months. Some 2 or 3 years. I've developed over the past 3.5 years. Akira and Zach, Vasirius, and Menelek, and Michael, and Akeem, and Terrence, and go on and on. The proper instruction, these type of instructions, man, was going to do it. This type of instructions, because it provides clarity, man. Oh my God. Whoa. Woo. You gotta understand, 25 years of misconceptions on my part. 25 years. I taught thousands of people misconceptions, thousands. Any questions, comments, criticism?
Well, I would like to say I truly appreciate the class. I am learning a lot from you guys, even right now. Not that I haven't learned a lot, but you're speaking on the misconceptions, and I appreciate that. So, gratitude.
Thank you, sister. Brother Taylor.
Peace, brothers and sisters. I just wanted to speak on how truly it is a blessing to be upon you guys tonight. And you know, the truth lies in the paperwork. Everything leaves a foot trail. I'm pretty new to living as a free man here in the US. I've claimed my estate back. I've claimed my estate back from the government this past August, but I know it's still a long journey of correspondence and also a long journey of ultimately gaining knowledge to teach it to my family as well, you know, and it's just a blessing.
Let me cut you with it for just a minute. When you say you gain your estate back, you just gain your estate back. How what do you mean when you say you just gain your estate back? What do you mean by that? Express that.
What I mean by that is I'm no longer a ward of the state. I'm pretty much on the land. I basically did what's known as a status correction, correcting the government of the misconception of me being a U.S. citizen. The 14th Amendment states that we could break away from that same Constitution without penalty.
Let me say something. When you say you got your estate back, the first thing you do is you come back to your country for protection. You go back to the 1880 Act of Madrid stated that, and 59 Congress said that Moors, when Moors want to get their protection back, they go back to their country. I mean, it got to be a national government. See, our government been dissembled. We got to assemble our government together as one national body and go to a national body and get what you call documents. See, the treaty talks about documents. Documents, a certificate of consequentity. That means that ties you back to your country because because the government is standing behind you to verify that. Acknowledging self-determined body of people deposit an institution, deposit a constitution and an instrument with in the community to be recognized as self-determined people. Therefore, now when a document comes from your government, it's called government-to-government relationship. Now, they ask you how you do that. You say, well, I got my certificate of consequences right here. It got the seal stamp of your government as a protector. Your mother, you got your, that's your mother paperwork. It's your mother. It's something coming from your mother, the country. It come from you. That's how you get your standing. That's proper standing. That's why when you go to a government building to get identification, they ask you for your birth certificate. Look what they're doing here. They create this system. So what? They ask you for your birth certificate. That's a consequency certificate. Your birth and your consequences. What that? I want to say the Commonwealth of Virginia. Well, that's your birthplace. That's your mother. So the state is your property. You probably stay in property. You probably stay. You still is.
Right.
When you
so
say
what
that,
I got the apostle. Is that why we get our apostle seal on that document as well?
Listen to me. Please hear me out, please. The reason why I'm saying that because other people are listening, I want them to get the understanding when you say I claim my estate, my body back. I'm saying that you have nothing until you come back from your government. To your government,
I still have to do more.
Certificate of consequence your government do for you. Therefore, you got a document from a government, which is under treaties, a flag, a signal. Your paperwork should be shown. You got the paperwork coming from your government. You mean for my mother, the state, the country is your mother. The country gave you your paperwork or your consequentity. So I know who my mother is, Morocco. That's my mother. That's my motherland. So now when I go somewhere, I don't have to do nothing. Because what happened is the government sends to Homeland Security, the State Department, Department of International Affairs, through the central authority a proclamation of all the web links, of all the websites, all the look up certain identity of foreign nationals, and they do it for you. So you won't have no problem. Now a proper claim has been put in there. Now you have to worry now of being kidnapped. You don't have to worry about that stuff because it's properly set up now the proper way.
Yes, sir.
This is what I was talking about, the misconceptions, brother, that you just, brother, you talked about a misconception that I taught for 25 years. What you presenting, brother, I taught for 25 years. That's a misconception, brother. That's a misconception that you brought to the table. That's why Shem asked you that. We have to restore our mother.
Right.
And
In other words, see, we gotta go back and look back to Coverberg. Look back what they doing. What they do, they're exercising old principles, cultural principles. Like on ancient time, how do you know you was from a certain tribe? By the marks in your hands. They can open your hands up, look at the palm of your hands, and look at the symbol. This is the best DNA in the world. Cultural marks. And your hand. So certain things the tribe would do, the tribe would, what you call, put a mark on a person, which is called like a tattoo, is a mark. To identify you being from that tribe. Some tribes identify you by the mark on your hand, your palm of your hand, or certain things, lines you got. See, this is hidden from us. So what we have to understand, when you go back to your mother give you the paperwork. That means my body is a vessel coming from this land. It's part of this geographical land right here. The physical land. My mother came from here. My father's, my mother's. So now I got a certificate of consanguinity to show where I come from, where my mother come from. That's very important. Nobody's teaching this. Honestly, they don't know. They don't know. This is why it's very important. We're born at a time now, changes are coming. Are you go along with the change or you be left behind? That's how it goes.
Yakub, you had your hand up?
Doing an applause. I was doing applause. I was loving and thumbing up and clapping.
Oh, that was a
Okay.
applause. Oh, you was clapping. All right.
Yeah, I was clapping and thumbing up and hearting and loving.
All right. Any questions? Any other questions?
Islam, I have a
Go ahead.
Was that
yeah, I have
Stern?
a statement. Islam, y'all. Yeah, what I'm noticing amongst our people is that we are fixated on doing it as individuals. And we have to learn that our unity, political legitimacy is key. I'll yield the floor.
All right. The reason why, Stern, is that the reason why conscious Moors are fixated and doing it individually, because they were taught by conscious Moors to do that. Conscious Moors taught that. Conscious Moors will hand you, a conscious Moors will hand you a proclamation and tell you to go to your job or send to certain agencies. Means that it's sent from your house. That you, Stern, you send the paperwork. You get the paperwork from a conscious Moor. I know the misconceptions very well, brother. You get the paperwork from a conscious Moor. They got a name of some entity at the top of their paperwork, whatever. They seal it for you and all that, and they tell you, I mean, that they have not been open diplomatic challenge. They tell you to go to your job. They tell you to send it to 8 departments. It's not sent from the government entity to your job. The government entity doesn't send it to your job. Your job, they tell you to give it to your job. They don't, meaning that they don't deal with the top down. They don't deal with the top and then the communication lines, all right? The central authority. They're not dealing with the central authority and they're dealing with the communication lines. That's why conscious Moors taught you that. And I was one of them for 25 years. So blame me, I'm part of the problem. I was part of the problem too.
It's like, since we were taught that, and I have done the same thing as far as sent my own proclamation of paperwork out.
Mhm.
How can you correct that as of now?
All right, you in this class, right? You in this class. This is
Yes,
how. All right. No, the how is what you're doing now. The how is what you've been doing for the past hour and 9 minutes. That's the
Yes.
how. I'm just being practical. I apologize for being practical. The how is participating in these classes so that you can learn. All the recorded classes are uploaded on the Moroccan Post Media YouTube page. This is the how. How did Michael learn? By studying. How did Shem learn? Study. How did I learn? How did Terrence learn? Akira, Akeem, Sirius, Yannick, Menelik. Those are on right now. Sheehan. They've been with us for 4 or 5 months. The names I'm calling now been with us for 4 or 5 months. Your Stern been with us for 3.5 years. DuPont been with us 3.5 years. How do they learn? By studying. This is how. I mean, it's not, I don't want to make it more than what it is. This is how. Just like the brother, the way Shem broke it down, he said, I don't want to cut your wisdom, brother. And Shem broke down the proper procedure in the context of government structure and how we're addressing misconceptions after misconceptions. We've been doing this for 3.5 years. All right. Any other questions?
Peace. Abdullah, can you hear me? Can everybody hear me?
Is that Sheehan?
This is Shem.
Yes, peace, bro.
Peace. So with conscious Moorish, I want to speak to that. So there's emphasis on the Europeans violating the treaties. So would it be fair to say that we've been violating treaties through the different processes, the different in our misconceptions? Have we been violating the treaty also?
Yes.
Well, we
why,
have not. Go ahead, Jim.
Yes, you have. That's why they can't be blamed. See, what they do is they document the program us to do this. Let me show you something. Remember what we did called an art of war? See, we talking about the art here. Art of war. This is the art they do. They program you and dominate you to violate your own laws. How do you violate it? Through the language. Construct fictitious conveyed language. By the language they convey to you on a false pretense, it programs you to do what? To go around here and what? And be not knowledgeable. So ignorance is no excuse of what? Not being protected. So what they do is now, they can escape the international community coming in here straighten it out because we're not self-determined because we claim to be what? Through expatriation, we're making what you call an involuntary claim, meaning to duress, tricks, deceit, and duress. We're being told that we are what, Black, Afro-American, colored people, and Negroes. Through that constructed language, that's deceptible. That's deceit. That's deception. That's fraud. And what happened is, as long as they can do that, the international community say we don't recognize them as what? A right to self-determine because they haven't deposited what? The Constitution as a people to self-determine, recognize themselves. But therefore, the domestic citizens, and we can't get involved with domestic citizens matter. They have their own matter themselves. That's how it goes. I bring it that clear and dry. Yes. Any more questions?
Islam, thank you.
Yes.
All right. Want to continue reading? So Amanda, it's important that we take our time though. We want to take our time, do this. We're not rushing. These points are very important.
That's why I cut the brother off because I know people listening. If I don't
Yeah.
press this right now, then everybody take that as being president. A president case. It's presidential. I mean, it's head. It's stand decision. I mean, we can do this. Yeah. No, you can't. It's wrong. No. What we do for years, like Abdullah said, I was taught, and I was also talking like this for years. Misconcepts. And guess what? I went through the system a couple of times. I realized one thing. This is the way to go. You need protection. We don't have no protection.
Jurisprudence,
Yes. Go ahead, Amanda.
jurisprudence and the writ of Quo Warranto. The United Nations Declaration of the Rights of Indigenous People is a contract binding on the United States based on prior contracts and treaties that were signed. The Moors should not do anything else besides go back to the science of jurisprudence, facts and norms. Moors have to learn how to rely on and stand squarely on the treaties as our binding ruling principle document and nothing else. The European colonial states are assuming that Moors are part of their society, and as a result, the states want the Moors to rely on their contract, the European colonial states' constitutions and the United States Constitution. The constitutional alliances shall be binding on the European colonial states and not the Moors. The jurisprudence of Article 6 of the United States Constitution, all debts or engagements entered into before the adoption of this Constitution. The United States is a debtor to the Lenape Moors. The British subjects became in rebellion when they fled from the colonies, and as a result, they became an enemy of the British Crown and her colonies. The British subjects who were in rebellion to the British Crown signed a treaty with the Lenape Moors. The British subjects and the Lenape Moors did not sign a peace treaty because they were not at war. Therefore, the United States is in debt to the Lenape Moors to this very day. The Moors granted the British subjects amnesty for their crimes against the Moorish allies, Great Britain, France, and Netherlands. The treaty between the Lenape Moors and the United States of 1778 formed the first United States. The British subjects are recognized by a sovereign body. The Lenape Moors gave the British subjects amnesty as the British subjects became enemy of the British Crown, while the Lenape Moors are friends to the British Crown through treaty. The United States founded its sovereignty and sovereign claim or power on the 1778 Moorish Treaty with the Lenape Moors. The United States is operating on the authority from the 1778 Treaty. The United States authority is derived from the 1778 Treaty. The Lenape Moors acknowledged the British subjects in rebellion to the British as a sovereign political organization when the Lenape Moors granted amnesty to the British subjects and entered into a treaty with them. The British subjects have never been relieved from their tax obligation owed to the British Crown under the charters. The Second United States was formed under the Articles of Confederation in 1781, which is 3 years after the forming of the First United States, formed through the 1778 treaty with the Lenape Moors. The Articles of Confederation of 1781 and the Constitution of 1789 are not the derived authority. The British subjects do not have inherited sovereign power to operate without being delegated authority from the Moors' own Moorish soil or on Moorish soil. The British subjects wanted to operate outside the British Crown. The British subjects do not have the inherited sovereign power to operate outside of the British Crown's authority. The British subjects wanted to operate outside the British Crown.
All right, stop there. Jim, you want any questions?
I just want to read the last
Yeah,
one.
I apologize. Yes, go ahead, Amanda.
Sorry, I was reading it twice. The other one. The British subjects did not have a treaty with the Moors prior to the 1778 treaty.
Yes, thank you.
Okay, let me say something. The power to title Now we talking about title now. I'm talking about something separate now. See, the British government nor the French, Dutch government did not have a right to name. For instance, let me explain what I mean. When they signed the treaties in the 1600s, 1700s, 1500s, the indigenous people, native people of this land was called Moors. What the British government did was went back to the land and came up with a scam. And to take the people from the treaty rights of the old Treaty of Granada, the old Moorish treaties of 1600s, they call it Indian. Now Abdullah broke that down. Indian means river or lake or a river, lake or swan. So when somebody say they are the Indians, that means you're the swan people, you're the river people. So what they did was in the treaties, it does not say Indian. It does not, when it say Indian, it does not say Moor. You say rivers. You say lake people, the lake people. What you mean? Indigenous people fishing around the lake. You see a man fishing around the lake. You ask, who are you? You say, I'm a Moor. He said, okay, I want to do agreement with your chief. When they do agreement with the chief of the tribe, and they say, well, we will call y'all people the lake people, which is Indians, the river people. Why? Because we consider y'all being swamp people, living around the swamp, fishing and hunting. You just stole a consequentity from them. Now why? Because you go back anciently, their ancestors never identified themselves as swamp people or river people. So what you just did was you conned them. They're called deceptive. So the only way that can be corrected, when I said living there be Moors, I was saying Indians, because if you read the 1744 Lancaster Treaty and the Area Court Constitution of the 5 civilizations, the word Indian don't come up, and the people they call themselves the swamp, the river people or the lake people. So you see, as jurisprudence, as a jurist, when the Supreme Court hear a case, what the Supreme Court do is go back to old writings of old common law writings. They look back to the old writings. And the only thing they can legislate based on what? The common law of Great Britain, the common law of France, Dutch, Sweden, because that's what they are. The Europeans here are Swedes, Dutch, Portuguese, Irish. So they go back to the old Irish traditions, cultures to talk about their settlement, what they had before they became an colony. So what we have to go back and say, excuse me, if I go before the World Court, I would never say Leonard be India. I would say Leonard be Moors. They said, why you say that? Because the Moors are the first ones signed treaties in the 1700s, 1500s. There's nothing in them treaties that say Indian. What the Indian coming at? That's a misnomer. Misnomer. I mean, the word is not to be used. That's
Let me support you, Shem. I'm going to support Shem.
Go ahead. Yes.
In New Orleans, French law, if you were an attorney, a law student in a law school in New Orleans, you're going to study French law. You're not going to study British common law. You're going to study French law. If you go to a law school in New Orleans, you're going to study French law. Why? The treaty, when that was ceded to United States, they maintained French law because of a lot of the land grants. I'm supporting what Shem's saying. This is where study comes in. A lot of the French land grants. So that because of the French land grants, they maintain the French common law to this very day. Because that's based on the French land grants. Because France had occupational extended French territorial sovereignty to that, because you had, remember, the Louisiana, all right, which included New Orleans, and it was ceded to Spain in 1762, when Great Britain made an agreement with Spain after Great Britain defeated France. So the 1762 Treaty of Fontainebleau between France and Spain, where France ceded, by virtue of agreement with Great Britain, ceded Louisiana to Spain. Those French subjects, those French never left. While France had extended her Spanish territory sovereignty. The French subjects still remained there. When Spain receded it to France in 1801, and France ceded it to the United States through the Louisiana Purchase Agreement, those French subjects never left. Article 3 of that Louisiana Purchase Treaty is the citizenship clause. Those French subjects became citizens of the United States by Article 3 of that treaty, that Louisiana Purchase Treaty. This is where study comes in. Well, I can speak in detail about it. This is what they operate on today. This is what Shem is talking about. We have to know this. Why? Why is it important that we know this? Because this is our land. This is our land. We must know the politics that's regarding our land. You can't ignore it. It is unintelligible. It's unintelligible to ignore it. This is our land. This is our land. This is our land. It's unintelligible to ignore it. It has to be addressed, but we have to know it. We have to know that this is our land, the politics that regarding our land. You have these European land boundary cession treaties that they're operating on. And when you start seeing the different maps that came about, they're ceding our land from one European occupying sovereign to another European occupying sovereign to another European occupying sovereign. All right. Amanda, continue.
Command the judge to issue the writ. Judge has the power to issue writs under the All Writs Act and Article 3 of the United States Constitution with disputes dealing with treaties. You have to move the court by commanding the judge to issue the writ on the default of the Attorney General. If the Attorney General of the state answers that within the statutory time, the judge will allow the writ of Quo Warranto to be placed on the record. If the Attorney General of the state files an affirmative defense denying the facts and merit in the writ without attaching any reasonable explanation and an attached copy of the treaty, then the writ is considered as proof of claim. Note, it is not the discretion of the state to deny Article 6 and to render it to be ineffective. Remedy. Command the court to issue the writ based on the language in the treaty. Note, the affirmative defense filed by an attorney general of the state does not have standing grounds to deny the obligation and stipulation that said plainly in the treaty on the merit of constitutional contract law. It is not an option of the states to render the treaty defective when Article 6, Section 1, 2, and 3, the Supremacy Clause, oppose any such argument or contrary school of thought. If the states are allowed to do that, they would overthrow all of the jurisprudence and positive law that is the foundation in which the United States Constitution is based on. Article 6, the Supremacy Clause in the de jure Constitution, acts as a confessed judgment against all public officials and state authorities operating and usurping authority that's not delegated to them, and in the Lenape-Moorish Treaty, the Delaware Treaty, and the Constitution of the de jure United States. Note, go into the treaties and simply say that the treaties are the only authorized contract that empower both high contracting parties that sign that instrument and the Constitution. Article 3, Section 2, Clause 1, allow the federal court to issue the writ to protect the foreign party's rights. Note, you cannot enter the precipice because the clerk of the court does not have the power to issue writs because you are challenging the sovereignty of the state. Writ of mandamus compels them to comply with the language in the treaties and work with the Moorish consul or sheikh and or British consul to intervene pursuant to the language in the treaties when affecting a public minister. The writ goes directly to the Supreme Court, which has original jurisdiction pursuant to their constitutional mandate. Writ of habeas corpus compels them to produce the body pursuant to Section 2 of the Judiciary Act and show cause that they have the jurisdiction pursuant to the executed language written and said in the treaty. Writ of Quo Warranto and Federal Rules of Civil Procedures, the state attorney generals, and writ of Quo Warranto. 1, file writ of Quo Warranto in federal district court in the district where you domicile. 2, serve to the state of origin in care of attorney general. Note, pay the cost to have the federal marshals serve the writ to the state attorney general. 3, attorney general has 30 days to respond. 4, file notice of intent to enter default of judgment for failure to respond in a timely fashion. 5, file a petition to move the court to issue the writ. Note, the order shows proof that the state attorney general has no delegation of authority based on the treaty.
Shem,
Yes.
you want to elaborate?
Yeah, basically, when you have a government, right? Your government got to be responsible for serving documents. If you're going to serve the Attorney General of the United States or any agency, you go to the head authority, central authority. They already got what you call prescribed officers that serve documents under international law. So what you do is they serve it through that government. All the government can do electronically through fax or electronic scan it to the government, the proper government agency. Once they do it, they serve, because that government agency is there to serve you, and they have proper officers there that do that. So you don't need a marshal of the court. You got somebody higher than the marshals now. So therefore, once they serve, they have to respond, because it's a higher tribunal. Let me go back to the beginning. First of all, the United States don't have no authority. So I'm gonna get this straight. Without treaty, the treaty was the proper delegation of authority for the United States to go back into the colony territory. Let me tell you, they will not be able to exercise authority without that treaty. So therefore, if treaties are not the law of the land, any state can rise up and say, well, I'm not going to do this. Therefore, they no longer have a right to be, no longer have a right to be in a colony. You can't say, I'm self-governing myself in somebody else's political jurisdiction of the crown. So therefore, you have to honor the treaty for you to stay there. In order for the United States to operate their government, they need a lawful title. The treaty gives them a lawful title to operate. It gives them a license. Please hear me out. They would not have a license to operate without that treaty in the colony territory. The colony of Virginia, Pennsylvania, all that existed already. All they did adopt as corporations the name. What they did was they incorporated themselves under the crown territory as corporations of the colony, and they hide it. Don't teach it in school. But this was going on here. That's why, let me explain something to you. When the Constitution is written by who? Esquires. The Esquires is controlled by who? The Crown. The Crown struck the Esquires to put a clause in there to make sure that anything we do with the United States through treaties, all these foreign powers, the United States and all these jurisdictions in the colony, while they operate in the colonies, that treaty becomes lawful authority in that colony territory. Why? The Esquires wrote that, not common people. See, everybody say, oh, Esquires sell you out. No, Esquires wrote your Constitution. Yes, the Esquires wrote your Constitution. So therefore, it was under control of the Lord Proprietors, and the British Crown was being written. That's why they put that there for, to make sure that the United States stay licensed as a licensee, obey that treaty. That license, they receive a license. That's all it is. Go ahead, Abdullah, you add?
No, I don't have anything yet.
Any questions?
Any questions?
Peace, I had a question.
Yes.
Listen, Shem. Now, we're as far as the Lenape Treaty of 1778 as an instrument, and let's just say the Treaty of Peace and Friendship. I think it was it 1836 between Great Britain and the Moroccan Empire. As far as a document is concerned, would one be considered international and the other one domestic, or could you clear that up for me as far as the treaty is concerned, the treaties or an instrument is concerned?
I mean, does
that make sense?
Yeah, yes. This is called Moorish science. I'm gonna teach you real Moorish science. The Sultans came over here and conquered the Moors in West Africa. This is not North America. This is West Africa. Northwest Africa we're in now. When the Moors came over, when the Sultans came over here, they came here in Northwest Africa and conquered the Moors, which was called Indians. They conquered them. They became Moor subjects. Yes, they became Moor subjects. The Indians are Moor subjects. So what's going on is now the United States. When let me explain something. When that war happened, it wasn't just the common people. It was the Lord Proprietors, the dukes, the earls, the counts. Everybody rose up. Why? The commissioners, the presidents, everybody rose up against the crown because they were being oppressed by the people. People were being oppressed against them to take their life. So therefore, there was a conflict in-house with the crown. So what the crown did was, the United States was the House of Representatives that was appointed by the Lord Proprietors rose up against the Lord Proprietors. The House of Representatives and the Congress rose up at their point against the Lord Proprietors. When they rose up against the Lord Proprietors, it rose up against the crown. And the common people followed them. So what happened was, they didn't have nowhere to stay. They didn't have no land. There was no land given to them. They were renegades. They had no land. So what happened was, they came to France and signed a treaty with France. They came to Spain, signed a treaty with Spain to help them fight their wars. And they need asylum and protection. And they came to Lenape Moors for asylum. What you mean? They wouldn't need food, they need clothing, they need shelter, and they need to be a friend of a sovereign of the land. So what happened was, in order to attack the British, they had to go to the French and Spanish forts, territory to attack the British territory. That's why they signed a treaty with Spain and France. And in order to go with the British, they needed Lenape Moors to fight on their side and give them amnesty, feed them, protect them. So we gave them asylum and amnesty. They were considered as what you call migrants. They was migrants. Why? They crossed the border. They came into what you call a territory of a foreign nation, Lenape Moors. What happened is, when the Lenape Moors and France and Spain helped them in the war, it forced Great Britain to sign a treaty with them, because Great Britain said, if you come out better, sign a treaty, allowing them to go back into the territory, self-govern themselves, as long as they use our money system, as long as they pay us taxes. They're still paying taxes because they're not using their own money. And they borrow money, they borrow gold to run their government. They need gold to run their government. They need valuable to purchase things, so they borrow gold. So it was in debt, they're debtors. What they did was, the Congress and the Esquires came up with a plot to take the Moor subjects and find a way to enslave them or put them in servitude so they pay their debt. So they'd be indebted to them, and they use them as farmers and plow the land as servitude, as servants to pay back their debt. And that's what they did. You understand?
Yeah. Is in a way, I'm just trying to distinguish. I was trying to distinguish the difference between the instruments on it. But that I guess when you say that when it says that those are they came over and the Sultans conquered Northwest Africa, which being
the whole Africa, not the whole world. The Sultans conquered almost anything in the world. Northwest, Central, East, South, North Africa. They conquered all that. Yes, they beat out the Roman Empire. When they beat the Roman Empire already had conquered the Roman states representing the Roman Empire in Africa. Portuguese, Denmark, Spain, Dutch, the Dutch Empire, all represent the Roman Empire, which came under control of the Catholic Church. They came down to Africa, and what they did is 1859, the Berlin Conference, they took Northwest Africa and annexed it, took all the land and Moorish people and said, this is North America. They took it and annexed it to a political jurisdiction of European crowns, which is America, North America. mean, what, all the European power, Dutch Empire, the Portuguese Empire, the French Empire, the Spanish Empire, all of them are the jurisdiction of America. They're all America. They've made America up. That's why I say United States of America. What you mean, United States of what? Of the British Empire. That's part of America. You understand?
I got you.
See, we got to understand what's going on. In order for it to be corrected, we got to next out our own land. They took assignments out our own land, took all our rights, and expatriated us into a foreign jurisdiction. That's what they did.
So under
That's
that,
what-
so that's 1778 treaty. So on a basically on an international scale. So even under the jurisdictions of the sultans, so those particular clans that were party to the 1778 treaty, that would be like 5 separate political. Those would be 5, or I think it was 5.
Let me say something.
Five separate political bodies under.
No. You talking about, no, that's Lenape Moors. That's the Lenape. No.
The Lenape are people. There was an empire itself. The Lenape people was a part of the Wichita Deltamani Empire. There's ancient people, indigenous Moorish people. Let me explain something. The United States signed a treaty with Great Britain. They signed a treaty with Spain. They signed a treaty with France. They signed a treaty with the Lenape Moors. Now, you understand what's going on here now. They don't use the word Moor, they use the word Indian. Why? Because they're assuming the common law practice of Great Britain and Spain when they call the Moors Indians. They're called birthright stealing. They're stealing birthright. How you steal a person's birthright? Change their title, their inheritance, title to the land. Take away their claim on the land as the original people that signed treaties, pre-treaties before they were born. Like Abdullah said, based on a document Abdullah read from the Treaty of Granada, one of the classes, they were going to steal the rights that Moors got under the Moorish treaties of the 17, 16, and 1500s. By saying Indian, you'll strip the Moors of their right protection under them treaties. Because you said we're not dealing with Moors, we're doing what? The Indians are considered as what? They call it, listen to the word, listen to the word they use, Native American. How can you be a Native American and the word American didn't exist? The word American didn't exist because the European powers haven't what? Haven't colonized Northwest Africa the proper way now. So you can call the people now indigenous to the land, Native American. Let me say, you know what he's saying? You're saying y'all European slaves, servitude, servants. Yes, that's what you're saying. European servants, subjects. That's why you're saying you're subjects of the European powers. When you say Native American, what is Native American? A subject of European power. What is a Moorish American? A subject of a European empire power. Yes. Colonial. Yes. Because the word American is in there. In America, American is what? One that's claiming to be what? Under political existence as a citizen of one of these European empire powers. Dutch, Sweden, Portuguese, Ireland, all these European powers. When you say you are American, you say I'm a citizen, or what you call a kin to one of European powers, descendants. The political allegiance. See, these words get you in trouble. So when a jury is arguing before the court, you don't use the words. Excuse me, I can't use that because during the 16th and 17th century, these words didn't exist. What do you mean? There's nothing in the instruments of the native Moors to say America. There's nothing in 16, 17, 15th century treaties that say the word America. They say the Dutch Republic, a Dutch Empire, or the Sweden Empire, or the French Empire, or the British Empire. So you got to stick with the language. And the people that sign the treaties are not Indians. So you can't use the word, and that's the court argument. When you say, well, we Moors, and our right was the natural way from us to what? To a proper legislation was not given by a decree of the government, then you can win now. Remember this, when France was going through with America with letters, France called the native people of the land, France said native Moors, they didn't say Native Americans, they didn't say Native Indians, they didn't say Mexicans, They didn't say Cubans. They said native Moors. France called the people they state their sovereignty with as native Moors. That's icing on the cake right there. Any more questions?
All right, Amanda, we have a question. King, Brother King?
Yeah. Can y'all hear me?
Yes.
Yes.
I got a question. Can Moors, since the emperor conquered Moors, can subjects as Moor subjects, were we allowed to enter in treaty and be looked at as sovereigns as it relates to the jurisdiction?
Yeah.
And
Yes.
did the king give us authority? Is it any more documents that once we were conquered by the emperor, did he leave us with any kind of documents to show that we were sovereign and could enter into treaties and recognize us as sovereignty?
Okay, let me say so. Let me look back. Let's look back now. The protection of sovereignty is the British and what the seers say, the prophets, the seers. That means on the consequentity of a nation, meaning something that was given to a nation to birthright by the powers of the unseen world, the hierarchy of the unseen world. A one man, a house cannot give a whole body of people sovereignty. The house to get their sovereignty to what? A seer. A seer anoint the house as a royal house and give a certain exemptions and status, high status, prestige status over the rest of the houses of the nation. No one kingship. Kingship is in people. Remember that. See, we gotta go back. It was never intended for no one king or nothing to rule the nation. See, the thing was, we were supposed to bow down to the higher power, celestial power, God. And we supposed to look through him, look for a way through his seer, the prophet. What happened was, when the people wanted to be ruled by a house, the head of the house of a one man, that was wrong. That took away what you call certain rights. Certain rights are stripped away when the people desire that. The only thing can happen if the people desire that. Like Professor Abdullah said when he reads some comments of ancient history, he's right. He looked back, and Abdullah looked back and said, wait a minute, no one can do that unless the people consent to that. Let me explain what I mean. Look at Great Britain when a government that was put in place by the Lord proprietors and ran the people, when the government rose up and the people, what did the crown do? The crown did bestow upon them sovereignty. The crown just allowed them to go back into their territory and do what they got a right to do, self-determine among themselves. That's all. It's right before our face. You know, man or woman to tell you that you're sovereign. You're sovereign because when you're born, you birthed that of the land. You have protection of the earth, protection by the air, the water, and land that you live in, you're born from. No one man, no one house can give you that. That was already stored upon the people, anciently. That right is protected by a seer, by the prophets. That's protected. No one house, no one queen or emperor or king or queen can ever give a people sovereignty when they got it already through their birthright, through their kinship. You understand? Like you got a treaty of the United States, Treaty of Days, the Days Treaty, the Treaty of Algiers, the Bays. Now, who's the Bays? That's a title, that's an office. A particular office held by a man or woman to hold an office for the people. And when they enter a treaty, that treaty is not just for the house, it's not for the office, for the people. Let me explain what I mean. Why do you think the Sultans, when they made the treaties, they said Moors, Moroccans? Who are they talking about? He wasn't talking his own house, his own personal house. He was the people, as the common people, the citizens, the Moor subjects, Moroccans. That's the people. They protected. Not only the Sultan, not only the house of the Sultan, but the people protected. Why? Because the people are going to be the one run his cabinet. The people are going to be the one run the cabinet. The people are going to be the one to put money in his treasury, to pay taxes. People didn't want to wait on the market scales, the commodities. They didn't want agriculture, giving so much agriculture to his house so they can eat. So he got to rely on the people. So the rights are on the people from the beginning. Cut and dry. The rights are on the people. Anything else?
Page. Page. Your hands up. Page Il Bay.
Yes, yes. Can you all hear me? Sorry.
Yeah.
Yes.
Okay, thank you. Thank you so much for the class. Okay, so I have some questions on the writ of quo warranto piece on the command the judge to issue the writ. So before this class, I had some errors. I did send a writ of quo warranto to all the parties involved and to the attorney general. The only one that responded actually was the attorney general, and they responded. They didn't respect the L and the Bay. They just sent it to the straw, and they said, dear Page, we have received your correspondence dated blah blah blah. Your correspondence does not form a contract or create any legal liabilities or obligations on the part of the state or any agency or official of that said state. We will take no further action in response to your correspondence. So, of course, the writ of quo warranto had asked them, hey, prove that you all have jurisdiction, blah, 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 injured party, and so on and so forth. And also I had.
Hello?
She muted herself.
Yeah, she muted.
Sorry, can you hear me now?
Yeah, yes, go, you muted for a minute.
Oh, where did I leave off? I'm sorry. You all know?
About you said that the attorney general responded. Go start. The attorney general responded. XET. What did you say?
Okay, yes. The attorney general responded, and they sent it to the straw, not the L Bay. So they said, dear Page, we have received your correspondence dated blah blah blah. Your correspondence does not form a contract or create any legal liabilities or obligations on the part of the state or any agency or official of said state. We take no further action in response to your correspondence. So they didn't respond to anything as it pertains to the quo warranto in terms of proving jurisdiction. I had put, of course, the treaties in there, my rights, and the protection of my rights. And so they didn't respond. That was the only party that did respond. But what they did do, though, was the judge had recused himself, but that was after I entered a default judgment on this case. But the judge had put up another charge, and the charge was tampering with a judicial officer or threatening a judicial officer. And those were the only things that I found. I've never even spoken to this said judge. So, that's what I wanted to put there. But I'm learning a whole lot about this process that you all have, are sharing now. And so I just wanted to know, how can you go back to correct things that you've already put on record?
I want Shem. First of all, Shem, speak to what she talked about. Speak first.
Yes.
Before you answer her question. About
What's going on? What's going on now? You issue a writ. A writ is filed by one party into a court, into a judicial or legislative power have power to enforce that writ. I mean, government agency or government office. So what you did was you filed a writ of quo warranto to say they have authority to handle your situation. But here's the good thing about it. Title, they still got title over your body. So they're looking at you trying to file a writ to intimidate them. What you mean intimidation? You're intimidating them by the writ by saying you trying to intimidate us as if you got, they know the writ is issued by government office, government authority. You don't have government authority to issue a writ or to file a writ to us. That means that you file a writ as if, let me explain what I mean. See, you got esquires and attorneys, they file writs right to the courts. You file a writ as pro se, when you prosecute your own case. First of all, the judges already know that they don't have authority to hear that because you're not a counsel. Number one, you're not a government official, you're not a public minister. So you don't have authority to do that anyway. You try to intimidate them. So it's a good thing they lock you up. That's a good thing they lock you up. In some cases, they lock people up. Call them down there and lock them up. So if I tell people, the danger in doing this is that what happened with Lamont. You keep going down and messing with people, they go do a search and say, you know it's God. They call all the they call it FBI, they call it Central Authority. No, the UN don't acknowledge no government that's self-recognized or have a council. Do they have a council notification? Have a proclamation that sends to Homeland Security? The Department of International Affairs know anything about this council or this government? No. So what they do when you go down there, they lock you up a person that's a public official. They arrest you. So you try to intimidate us. You try to operate the capacity as if you're a government official that hold a government office, and you don't. So they can lock you up. It's a good thing they didn't arrest you.
I think he'll come back here and try to set you up.
Joe, I think Joel's line is open.
Who's line?
Your thing, you can let anybody set you up.
Excuse me, can you put your phone, mute your device?
I can see how could you do that when
Tim. Thank you. All right, so sister, I want to stay with you, Paige.
Yes.
You said that you were challenging jurisdiction based on based on what?
Based on this particular, like I said, the case, it was a traffic / criminal case. And so I had, talked to you all the last class because Lamont was my counsel at the time. And so I was just following up under the instruction of what he was doing. But like I said, I had come into you all and, later learned that the counsel was supposed to do that. And I asked, like I said, him to issue, if he could issue the writs and also the letter of rogatory. You see what I'm saying? But I had talked to you last week, or I'm sorry, a few weeks ago about that.
November 30th.
Yes, that class. I
remember. Shem, you have anything else to add?
No, just that you gotta be real careful because when you say issue, in other words, when you claim to file certain documents, you claim an office. It gotta be an office. You claim it as a board to file a writ commanding the Attorney General of the state. And first the Attorney General look at who this the person there more, where's the government counsel at? Where's the government official at? Now you're going directly to the Attorney General. What you do is you're intimidating him now. You stating that you act like if you got power, the whole office, to compel him to do something. But a council can compel him to do it because the council are lawfully authorized by treaty to do that. I mean, the council carry diplomatic immunity and exemption from prosecution. You don't. That's why it's very dangerous.
Good point, Shem. All right, that's what I wanted. Good.
Thank you.
This is what I was talking about, the misconceptions. This is where this level has not been taught like this. It has not. And Shem has really been for 3.5 years, giving, very detailed instructions on treaty enforcement through government structure. Shem I've never heard Shem talk outside government structure. Never. And all the conversations I've had with Shem does not talk outside government structure. I've never heard Shem have a conversation when he talks outside government structure. All right, any other questions? No other questions?
Could I?
Yeah, please.
Could I ask one more question? So,
Yes, yes, King.
as a Moor who has sovereignty, who still is part and parcel to the treaties, how do one protect itself from these government officials when there's no Moorish government structure? When the structure is not there, he still has the rights to the treaties. How
All right.
do he still get his rights enforced?
Let
when
me
there's-
just hold on. Let me just misconception. It's a misconception here. You said as a Moor who has sovereignty. All right. We got to understand you're talking you as an individual, Moor, who has sovereignty. The Moroccan Empire has the sovereignty. The Moroccan Empire has the Moor sovereignty. The collective sovereignty, Moor sovereignty, resides in the Moroccan Empire. That's a pre-existing empire. The sovereignty, the collective sovereignty of the people is vested in the Moroccan Empire. When you, as an individual, say, I am sovereign, no, Morocco is sovereign. Morocco is sovereign. Meaning that you don't want to walk around waving your hands saying you're sovereign. Because then you're saying that you're by yourself then. Remember, this is a pre-existing sovereignty. The sovereignty of the Moors is vested in a pre-existing government. We're not looking to establish this. We're not establishing anything new. It's called the recovery in international law, the recovery of lost sovereignty. Reversion to sovereignty. It's a pre-existing sovereignty, pre-existing treaties, pre-existing agreements. Notice that we reference pre-existing treaties and come under the protection of pre-existing treaties. So you don't want to make the claim of an individual sovereignty. You want the protection of your mother. Our mother is in the hospital. She's in a coma. So we have to bring her out of a coma. This is what we're doing. We're bringing our mother out of a coma through proper education and proper guidance, which would lead to political unity. Without proper education, it will not lead to political unity. So you're speaking to an immediate remedy. Shem speaks, he's asking for an immediate remedy, absence of the restoration of our Moorish government. What can Moors do now? That's what he's asking.
Well, let me say something to you. I'm gonna say this, and this, how do Moors get problems with the government? They gotta be in order for it gotta be running. And most time, Moors get in problem with the government because of driving vehicles. Number one, this is what we do. For a lot of years, we've been taught, oh, you can drive a car, you need a license, you're in your land, you're a Moor. No, hear me out. Hear me out. Please hear me out. Please hear me out. When he said what we can do now, you got to ask yourself a question. Why are we getting in conflict with the Europeans now while we're building? Now, brother, I'm going to ask you a question now. What's the majority of the Moors getting in conflict with what? To what? Law enforcement, right?
Yes, sir.
Okay. Now, you walking down, I know what you mean. You walking down the street and cops say, hey. Let me see your ID. You put a more, I'm gonna show you the problem is. You put a more scientific ID, right? And you say, what's this? I said, well, I'm a Moor and this is our land. And the more scientific or the ecclesiastical institutions that handling business for our people here in this district or the province. Now,
That's not having to do with the machine.
But your phone, somebody's got their,
What?
excuse me, mute your phone. Okay, Shem.
yes, what happened is the more is supposed to say, well, can you talk to can you contact my grand sheik? See, this is what I say about structure. Now, if you got a more science, you gotta have a grand sheik. Now, if you out there doing something individually, now I'm keeping it real now, and you say, okay, I can drive this car, I don't need a license on my land.
What do with the car?
Let's say you walking, and you could walking down the street, and you show him ID. You say, well, wait a minute. He said, well, can I see ID shown to him? He said, well, what is this? So I'm a member of a temple, Moorish temple, and this is my consequentity to my nationality to the Moorish science temple. And he asked you questions. The first thing you put say, I don't ask you questions. I want to talk to you. You asked for my ID, I gave it to you. I want to answer none of your questions. So if you got any problems, call the grand sheik or temple sheik, and then answer all the questions for me about me. Put the responsibility on your grand sheik. Now, if you don't have one, now you operate as what? Walking down the street, you got state ID, and you say, okay, right now they got you labeled as a United States citizen. So you say, okay, I'm gonna play the political game. You stop me, you ask my ID, get my ID from the state. What that mean? I'm a trust operating in the state. Okay, no problem. You gotta say that. You gotta say that you show me the ID. Ask your questions. I'll answer questions based on your own contract, constitutional contract. A man have a right, man and woman have a right not to answer your questions. See, hold to his contract. Based on your constitutional contract, I don't have to answer your questions. Based on your constitution, I don't have to answer questions. That's it. Now, when there's a problem, and you don't argue with this, you asked me for my ID, I showed it to you, you got it, that's it. The problem is most Moors, when I was growing up, get in trouble because they're driving a vehicle, and they said, well, I got a right to drive this car, I got a right to travel. And that's the main thing that a Moor got. We got realizing that vehicle, let me say something. First of all, the streets that you are driving are connected to the seaboard of the land. It's a shelf. On that shelf is like a pier, a shelf. The government buildings are operating as what? Vessels. Ships that's that dock on your land, on the piers. A pier is something that's connected to the land where ships dock at. Where merchandise is conveyed. What you mean? Merchandise, cargo, shipments, property, goods come off a ship. So therefore, the streets that's built on your land, that's construction. That street erection is their political jurisdiction on your land. So you're in their political jurisdiction. So if you operate, so if you don't have a Moorish government, you got to use the conditions you got. And how to use it. This I said, we not trained, we've been brainwashed, programmed. Not even the Moors been telling the Moors what to do when they get stopped. I'm gonna give you the best scenario to do. You operating in a more political jurisdiction, in a political jurisdiction of one of the foreign governments. Learn how to use their laws effectively to protect yourself as a trust. When somebody said, well, where you going at? You said, well, according to your constitution, I don't have to answer your questions. Now, that's the end of all that. Let him talk. You gave him the ID. He got it. That's the end of it. Now, a lot of problems is Moors start arguing with them. This is my land. I'm a Moor. Your law doesn't apply to me. No. You can't say that to what? That's a council. Your council said. That's when you got a Moorish government, you have to say all that. You say, excuse me, I'd like for you to contact the council, my national government. The council, the numbers on my card right here, the council. See, when you do that, the council speaks for you. But if you don't do that, you have a right to defend yourself. That's the right you got to defend yourself. How you defend yourself and have the knowledge what to say. What you say can hurt you. What you don't say won't help you. You got to be able to say things that effectively represent yourself. And how you represent yourself as a trustee of your body, your trust, your estate, your body. You got to say that to say, yes, ID, you go to ID. Ask me a question. Well, the constitution that you go by, everybody go by, say, I have to answer your question. I want to answer your question. I'm asking no question. And that's it. And be quiet. If you go for the course, The first thing, remember, you don't got no Moorish government, you have no council designated. So if you don't know, and nobody will step as a grand sheik or sheik to help you out, what you got to do is if you don't know, best thing you can rely on, say, listen, do have rights under in your political jurisdiction as a citizen. And the rights, these are the rights I want to be protected. And you got to be enforcing rights. See, the problem is, we're not going to get nowhere because there's no way in the world they're going to train, they're going to respect you because you're not an attorney, you're not a member of the Good Old Boys Club, the Bar Association. So therefore, when you go in and talking, you're being ignored. Nobody want to hear nothing you got to say because really you're incapacitated, you're an infant, you're retarded. You put that knowledge, you're a special needy person. What you do in the courtroom talking, litigating law? You're a special needy person. You ain't supposed to be there. This is how religious people beat them on the national level. They say, well, we're not part of your government. We got ecclesiastical government under what? The scriptures, under religious law, spiritual law, divine law. Therefore, our elder or our bishop will speak to you. That's how the Catholic ministries and the other ministries operate. They do. They got their own school system. They teach them this. If you have a problem, call this number.
Hey, Shem, hey, Shem, hold on. We got Paige has a question. Paige? We can't hear you.
Oh, I'm sorry. Hold on. Okay, what about now? Can you hear me now?
Yes.
Yeah.
Okay, so it's a two-part question. So just going back to what you were saying about the IDs and the Moorish identity card. My thing with the card is that, like, if you read the back of the card, the thing that bothers me is it says the beholder of this card is a natural de jure citizen of the United States of America. And I know Moors are not citizens of the de jure United States of America. I mean, I'm talking about all the nationality cards say the same thing. So I wanted to know, what does this body politic intend to do with creating the new card that separates us from being subjects of the United States of America, whether it's de jure or de facto? So that's the first part.
What we were teaching was all the communities of people come together and create their own Moorish provincial government state. And when they do that, they all come together and ratify, send a representative together in a national conference and ratify their own constitution, a national constitution, protecting their rights and reserving the right to their free rights to execute laws in their own political jurisdiction, and deposit that with the international body to self-determined nation. And now you have the right to self-determine. I mean, nobody can interfere with that. Then once you do that, your government issue your passport, your identity credentials that you would need to deal with the foreign subjects on your land. And how you do that through proclamation, executive orders, and resolutions to the foreign government into treaties. That's how you establish that. See, what happened is when you got a problem, when you give it up, already they got a proclamation sent to them, and you have a problem, they call a council. The council comes down, spit everything out. That's the good thing about that. All the lawful documents and authority that you have. In other words, if they stop you, first thing they do, they get a lot of people, where's your passport? You show ID, where's your passport? Why? Because the treaties say you need a passport. So what you mean passport? You're a vessel traveling. You pass a port. What do you mean? You're going from across one political jurisdiction to another jurisdiction. See, pass a port doesn't necessarily mean water.
Well,
that was off.
Hey, Shem.
Give me a minute. You cut it off. You cut it off. I'm your head off.
Tonight and tomorrow.
Let me get this real fast. Hold on.
Just for tonight.
You can't take care of it. He's there.
1022 0809.
Yeah, that was all.
Shem.
Look out, look. I'm looking over it. I just cut it off, brother.
Settle that real quick, man.
Clean the thing out, everything. Say that on slow, empty, like this. Come in, brother, you talking, bro. I don't know, I'm trying to get out of there. I knew it right there, but they got you distracted too, bro.
They take
Shem, mute your mic.
Come on. Yeah, it was true. That's why I felt that heat, brother. I wanted all that heat.
All right. Amanda, continue reading, please.
Okay. How to use the Moorish treaties and Moorish political structure to address disputes and conflicts. The function of Moorish consuls and treaty enforcements. Making claims through a political structure and treaty enforcement. Emphasis on treaty enforcement through Moorish political structure as opposed to individual processes and no Moorish political structure. Status and jurisdiction as key elements in addressing disputes and conflicts. Addressing disputes over land based on Moorish treaties. Read consul rights and not Miranda rights. 1, a Moor carrying his or her Moorish identity card. 2, a Moor hands the identity card to a United States or state of origin official or officer. 3, the official or officer, upon receiving the identity card, must read the Moor his or her right to a consul pursuant to treaties, acts, and international conventions. Any foreign body or people or agent bringing a claim in a capacity as a plaintiff must do the following pursuant to the Treaty of Navigation and Commerce between Morocco and Great Britain of 1856. 1, file a complaint in a Moorish court of law. 2, litigate any further pleadings after filing the complaint in a Moorish court. 3, subject matter of the suit is under the original jurisdiction of the Moorish government or any providence operating as a tribe or nation in the Moroccan Empire. If a Moor is a plaintiff in a criminal or civil proceeding against a foreign citizen as a British subject, he or she must do the following pursuant to the Treaty of Navigation and Commerce between Morocco and Great Britain of 1856. 1, file a complaint with the British consul. 2, make all pleading as a damaged party after the complaint is filed in the jurisdiction of the British Dominion. 3, this will be done by filing a letter of rogatory asking the British consul for judicial assistance following pursuant to the Treaty of Navigation and Commerce between Morocco and Great Britain of 1856. Procedure in exercising the jurisdiction of Morocco and the jurisdiction of Great Britain and England in North America. 1, if a Moor is a plaintiff bringing a claim as a damaged party, whether civil or criminal, the Moor must file his or her complaint with a letter of rogatory to the British consul. 2, if a Moor is a defendant in a matter, whether civil or criminal, the nation or state in his or her province of Morocco has the original jurisdiction to hear the matter. 3, petition to remove the action or suit filed by either a foreign government and her citizens or any subject of Her Britannic Majesty. The petition to remove filed by the Moor must be filed and processed with a letter of rogatory in the Moorish courts under original jurisdiction. 5, next, the petition must be certified by the Moorish court and deposit in both the clerk's office of the United States District Court or Circuit Court and filed in the state of origin, giving them notice that the case has been removed pursuant to the Treaty of Navigation and Commerce between Morocco and Great Britain of 1856. The cure for not instructing the Moor of his or her rights under international law, acts, and treaties. 1, petition to remove the letter of rogatory and a motion to dismiss for failure to read the Moorish national, his or her consul, or his or her right to be heard in the original jurisdiction in Morocco pursuant to the Treaty of Navigation and Commerce between Morocco and Great Britain of 1856. Note, the motion to dismiss must be filed in the original jurisdiction, either before a Moorish governor or Moorish judge. So 2, once the petition to remove and letter of rogatory is filed in the United States District Court, they must be attached as exhibits to removal that should be filed in the state court as evidence of the removal. Depositing your pleading in the original jurisdiction in Morocco. 1, the Moor national must file his or her petition for removal in the agency of the Moorish governor or file the petition in Moorish court, as well as attached as evidence, the petition to remove the United States District Court and the notice of removal filed in the state court as exhibits before the Moorish court. 2, after the petition to remove is processed and docketed by the Moorish governor or the Moorish court, a notice of removal with the attached exhibit of the petition to remove to the Moorish court shall be filed in the United States District Court. Note, pursuant to the Treaty of Navigation and Commerce of 1856, Morocco and Great Britain, if a Moor is a defendant in a criminal or civil dispute with a British subject, or anyone as a citizen of any United Provincial Colony, aka United States of North America, original jurisdiction belongs to Morocco. Jurisdiction in the French and Spanish zones in Morocco. 1, the Moorish consul has exclusive jurisdiction pursuant to the Act to Protect Morocco of 1880, the Act of Algiers of 1907, and the 1912 French Protectorate Treaty. 2, in the French Protectorate Treaty of 1912, the Spanish and French have the delegation of authority as the deputy of the Moroccan Sultan to hear and litigate any civil and criminal dispute under the Moorish consular jurisdiction. Note, in the Spanish and French zones, there are different procedural criteria. 1, letter of rogatory. 2, commanding judicial assistance. 3, assistance to enforce a treaty between 2 nations. 4, the consul or officer who delegates authority by the 2 treaty nations that signed and ratified the instrument.
Shem, you want to explain? You want to comment? You're mute. You still you're muted. You're muted. You're muted. You're muted.
Okay, Abdullah, no, that's yeah, I got you. It's self-explanatory, Abdullah. You laid it out so plain. That's plain. All you can do is ask questions on this. That's plain. You laid it out beautiful, Abdullah. That's laid out beautiful. Any questions on that statement?
I have a question. These are basically just the fundamental steps on how, basically just steps on how we are to structure our political body.
Go back and read the government courses that Abdullah they did. The 14-week course.
This is dealing with the treaty enforcement. This particular 1856 treaty between Great Britain and Morocco. Those are steps dealing with the enforcement of the treaty. Any other questions?
Hey, brother Abdullah.
Yes.
In the Spanish zone, that like La Florida, with it, that's under, that was be Spanish zone, right? Or it got ceded later through the Britain.
Yeah. Still, there's still Spanish land grants. There's still
Right.
Spanish land grants that are operative there.
Right.
Even though it was ceded to the United States.
Right. So would that fall under the Spanish jurisdiction, correct?
certain areas is based on the Spanish land grants. Yes.
Right. I got you.
Yes. Yeah, look up the Spanish land grants in Florida. Look up cases that's adjudicated on that. All right, so you can see, know for yourself. Any other comment? Questions? Brother King, you have another question of that? Was that? I know you do cases, King.
Yeah.
You want to talk?
Some of the things that I'm trying to get clarity on is more or part and parcel to the treaty. And we're talking about treaty rights. Treaty rights that's inherited due to your consanguinity. Your foremothers and foremothers left that as a right of inheritance. And when we try to claim that right of inheritance, I'm trying to get, I know we got to have the structure. This is why I'm here. Because they will block that. They will look at that as an act of aggression, and you will go to jail. And there's so many people pushing this. My question is, since it's not erected, and I know a lot of people.
You said so many pushing what? You said this. You said, hold on, now moving on. I want to make sure we clear on this.
Okay. Well, okay. A lot of people this is what they will push. They would use the Quo Warranto, they will commingle. What the United States would call it commingling. You will be commingling the jurisdictions. You will have one foot in saying that you are sovereign or you have rights to treaty, but then you got one foot in the United States jurisdiction trying to argue with them about their constitutional protections. You're arguing the Constitution and elements within the Constitution.
Shem.
Yeah.
Mute your phone.
That's Joel.
That's Shem.
So I'm just trying to get clarity on how Moors stay part and partial, because you can't serve two masters. You can't say, well, I'm a U.S. citizen, but also I have treaty rights. They're commingling the two instruments.
Yes.
The instrumentality.
You got it. You got the understanding. That's the misconception. That's been taught. I did the same thing, bro. I was taught that. That's a misconception that's still to this very day that's taught. That's part of the misconception, brother. You understand it. You understand. You are detecting the misconceptions. Absolutely.
So this is one of my questions on this issue dealing with Great Britain. Would we go to the British council or the French embassy, and ask for their assistance, ask them that we are Moors and would they assist us under the treaty, since they have treaties with Moors and it's self-evident, could they utilize and say they can speak on our behalf?
No, they can't speak on our behalf, because then you're saying that's all right for them to speak on our behalf. Then you're not coming as a government. You're coming as a subject. We wouldn't go to them to ask them to speak on our behalf. You're going to them in the enforcement of the treaty. That's not speaking on behalf. When you're operating government structure and enforcing treaty, you're not asking them to speak on your behalf. If you're asking them to speak on your behalf, that means you're a subject.
Well,
no, hear me out. No, this is for everybody. No, please, this is very important concept. You said go there and ask them to speak on on our behalf. That means you're going as a subject. You're going as a French subject. And I'm going to France embassy. I'm asking the French ambassador to speak on my behalf. I'm saying I'm a French subject. I'm a French, I'm saying I'm not saying that, but my actions by saying speak on my behalf, I'm claiming to be a French subject. We're not asking them to speak on our behalf. We're talking forcing government, forcing the treaty. This is why we're having these classes, so that we don't go to ask them to speak on our behalf. We have the knowledge.
This is why now we're dealing with the real, now we're bringing Quo Warranto. Let me explain what Abdullah is talking about, so you hear me good. Now, what you do is you contact the French, I got about the French council. Why? The French council, your right is to what? Your right is to force Moorish law in your French zone. This is French territory. And under 1856 case, the United States withdraw political jurisdiction out of Morocco, North Africa. Therefore, how can they have jurisdiction over Moors? They're not no longer considered as having political jurisdiction in Morocco. So you have the French to step in and say, wait a minute, if you got any matter dealing with a Moor, we are the only one that can handle matters dealing with a Moor. You ask the French to protect that Moor's rights you got, status. You ask them, you don't say, you don't ask them, you say force the treaty. That's all you ask them. I mean, what do you mean force the treaty? That the political jurisdiction in Morocco is given to the French Republic. Therefore, if you have a problem with a Moor, you got to go to the French government. That means the French government laws operates as a protector over you. I'm trying to give you common knowledge so you understand what's going on here. You're not a French subject. You put the French on the spot saying you got an obligation under the treaty to protect the Moors' affairs and enforce treaties. Therefore, the United States no longer have what? Jurisdiction in Morocco. Why? Because under President's executive order or resolution, he claimed that they gave a jurisdiction. So if you give a political jurisdiction in the country, you can't even protect your own nationals. How you going to force your laws in the country that you link a political jurisdiction in? It's impossible. So you have the French government, the council, to enforce to protect it. What you mean? Protect the Moors' rights under treaty. That's it. So anything they do, they are to the French government based on the French right to protect Moors' law or Moors' law. That's it, nothing else.
So my question was, Shem, when let's say we're in a French political zone here in the United States. So, do we enforce? So we're saying, well, look, you have an obligation to us, because in the United States Supreme Court that says where there's no obligation and duty, there's only exemptions. There's only exemptions. You only have obligations and duties. Treaties put on obligations and duties on other parties.
Yep. Self-executed treaties.
Right, self-executing treaties, right?
Yep.
And then you have multilateral treaties that a lot of these nations, when you come to the Hague and United Nations. But in this instance, so I'm asking, do we say, okay, when we're dealing in the United States of America and we're saying we have treaty rights, we are identifying the elements of the treaty. And there's other nations that's encompassing this jurisdiction. They have rights here too.
Yes.
Under treaty.
Yes.
Could we, as the French, could the French have evidence and communicate with the United States and say, we have a treaty obligation to the Moors here?
Yes, it's called a Fez Treaty, Treaty of Fez. Yes, they know about that. They're lost. Not only that, they got treaties going all the way back to 1500s, France, with the Moors. Come on, they know that. They're lost in the world court. They know that. And not only that, they were linking political jurisdiction in Morocco. So how can they prosecute a Moor in Morocco on his own land and they got a jurisdiction themselves? So you call for the Spanish consul and say, can you please enforce the Fez Treaty as a protector, protect the Moorish rights in their land? Because you are the protector. See, that's an obligation right there, self-executed.
That's what I was trying to get cleared up as it relates to treaty enforcement.
Good thing about it. I'm explaining what's going on here. See, we still are not organized into groups and communities. See, this agreement that France did called the Moroccan Judicial Assistance. Nobody know. I'm gonna send it to Abdullah. Abdullah, we're gonna go over it next time. Called Moroccan. They call it the Moroccan Assistance Judicial Assistance Agreement with Morocco and France. Now, let me say something. Anytime the Kingdom of Morocco signs something, they sign on behalf of Morocco. So we might well get that straight. Stop talking about them because they're doing their job. They do what they have to do to protect themselves. By doing that, they're helping us. We just don't know how to come together as groups, organizations, to register ourselves as the organizations to protect each other. That's all. That's why we're teaching these classes for, so we can set up remedy to protect our people. So the bottom line, we gotta start. Listen, we gotta start somewhere. Now you got a good idea. When you do that, automatically you put a stop to what they're doing. Now they gotta respect because the council he know already that yes, under Fed Treaty, and you cannot take away his right to nationalities and more. And you don't have jurisdiction to force your political jurisdiction in his land. So therefore, what he did, what's going on here? Well, they enforced the treaty. They would force the Moorish treaty because they're the protector. Yes, they have to enforce it. They're the protector. That's their job.
So let me ask one more question. Is it any other nation that we can go to that we have treaties, as we talking about the Dutch and all of these other foreign powers with? Is there any other treaties that we can stand on and say, hold up, United States, you have to recognize us because you have treaties with those countries, and these treaties, these people, we have treaties with them, and they can protect us also. Is there any other treaties that we can utilize to give
the British
us?
Treaty. The British Treaty, yes, you can. The British Treaty makes it clear that they will protect more. The British and the French treaties, a Fez Treaty and 1856 Treaty with Morocco and Great Britain, yes. The thing about it is not too many people that's educated that understand this. That's why we educate everybody for. But the key thing is this right here. So for so long, we've been going along, we allowing other people to do stuff for us. The thing is this right, all the world decided, all the nations of the world made a decision that people got a right to self-determine in their own land. We're the last people right now that have not been educated or programmed not to do this. So you got to do it. So we might just come down. It's better sit down and how long until they put together a group or community? It don't take long to put a group or community together. With knowledge, you get the knowledge, you can do it. With the knowledge, you can do a lot of things.
So that's what some of the questions that I was asking. Since we don't have this government, because I'm riding out with you guys, I don't know too many people who understand this information like you do. It's very far in between.
I understand. Yes.
A lot of people are still arguing, you know, even in the United States, I didn't beat them on their own laws. But even with that, there are judicial hiccups. And sometimes they don't like to stand on that. They sometimes let your case sit because they don't want to let certain things out.
I've been down the road 26 months. I sat there playing with them people. I know when you represent, just defend yourself. I've been through that. I know exactly what you're talking about. They punish you. So,
yeah, it's a lot of things. They're not even supposed to be dealing with. You supposed to be an officer. You supposed to take an oath for them under their statutes to even deal with you. But a lot of the criteria is that they're doing in-house policies. Whoever take the seat will then govern how everything moves. They won't necessarily operate under the law. Then you have to go through this long, tedious process. I was trying to give us some remnants, some type of remedy that we can utilize so that the people don't have to wait so long into saying that we resurrecting this government, this provisional government, as it relates to what you guys are doing. And I applaud you guys. I really applaud you guys for what you're doing, because nobody knows this information. That's why I put it in my heart to say I gotta follow these guys. These are the guys.
Well,
And
let me say this. Let me say this right here. First of all, look at it like this. A man is hungry. He got livestock. He got crops. He's hungry. I need something to eat right now. But still, what happened? All to eat, he got to process the food, the meat and the crops. He got to pick the crops. He got to process, slaughter the animal, and clean it. So, fish. He catch fish. He hungry. He hungry right now, but he got to do what? He got to process it. He got to eat the fish. He got to clean the crops. So everything is a process in life. It's a process. And what we got to do is go ahead and go through the process where everybody eat and be taken care of. That's what it comes down to. Nature. Nature show you that. You can't go something hungry and catch some fish and grow food and say, eat it just like that without cleaning it. You got to clean it first, process it, and cook it. If you want to eat, if you say you're hungry, you're going to do that. So if you say you want to be protected, then you got to come together and do it to protect yourself. That's what it comes down to. Cut and dry. Another kind of way. It's a process.
Shem, we got a question, Shem. Taylor?
Yes.
Brother Mr. Taylor.
Yes, sir. This actually helped familiarize me with I guess a question that I had, and it brought up a sense of unassurance. I wasn't sure of myself as to what's the next step as far as how do I go about doing this. This group, I'm pretty sure the information is here. I just have to ask the right question, or the question itself. And well, that question is, I've already filed several 1099-As and acquiring assets. For the most part, I got receipt back from the United States Treasurer's Office explaining to me that the next step for me would be to executing the direct transaction. And well, me doing my research and due diligence, I learned that me as the beneficiary of the trust, I can't act as the controller and trustee at the same time unless it's set up that way. And as far as finding a trustee to execute transactions, whereas though it won't result in penalty, is where I'm at right now, where I'm seeking knowledge.
The penalty means jail time. See what is going on. What you gonna start doing now? Putting people in jail when they do that stuff.
Yes,
because
sir.
You know what? I'm gonna tell you what. You operate against the corporate veil. That's why they're gonna do it. Because first of all, you're not commodity trading. You're not trading in commodities. The people are commodities. So what you do? What you doing is what you do following that? They look at you don't have a license. We didn't license you to do this, so they're gonna lock you on false pretense. That's their way out. They say you're a threat to national security, and you are.
Now, by law, do I have the legal right to do so?
Well, under government status, you got a right to do a lot of things because your status. But the status you operate under now, and the arena, you're going to them, and to them you gotta have a license. They do it with bonds. You file documents on tax forms, so you sign them as what? Who you sign as? The trustee of your corporation? See,
no.
First of all, they won't be the message to you if you sign as a trustee of a trust. The trust is doing everything because you authorized representative. You're not liable for a contract. So they will.
Well, I did create a trust in my name. I put my own personal trust. I created one.
To them, that's a violation of the trust bylaw. Know why? Because they got you down as a trust, their name as a trust, and it becomes a dispute on the assets. under international law. So therefore, if the trust was a property of a government state, protected, it got protection under international law. But what they're gonna do is they call everybody in there one day, knock on your door one day, and say, what's your car, man? Gone, locked up.
Right, right. And that's pretty much why I didn't go out and hire a trustee to execute the transaction, because I know I'm still solely responsible for everything. And I just wanted to be sure before I go ahead about doing things the wrong way, based off of what people have been saying.
Let's go back to what I say. The bottom line is, right now, you're hungry for a remedy. That's right, like a meal. You're hungry for a meal. The only
I'm
thing
homeless,
about it,
basically.
well, you can say, you said you need shelter and raiment, clothes. So what you do, you go out and find an animal, slaughter the animal to the clothing, to clothe yourself, to make gloves. And next thing you got vegetation. You cut it up, grow vegetation so you can farm. You go get the fish, you gotta clean it. So it's a process. See, sometimes we gotta be patient, and a lot of times we not patient to get the education. See, think about, we not educated to do this. And once we get educated, like you said, we start fighting each other. My process better than yours. Who you really hurt? Who you really helping? You're not helping the people as a whole. You're not no government by yourself. You're not helping the people as a whole. You only help yourself individually. And sooner or later, they will come for you. Say, nope, lock him up. They lock him up, nobody else can do it no more. So they lock you up because you're not protected. You don't have no immunity. You're not protected under national law. You're not a government official.
Right.
That's very important. Ain't about feeling, ain't about, well, what we're going to do. Listen, we know we got a problem. We know we got a problem. Like I say, if you know your house is roof leaking and your house leaking real bad and it's cold, the windows out, it's cold outside, the first thing you got to do is do repairing. You got to have the knowledge to repair your house. To board the house up, the window up, to fix the roof, or patch the roof on several leaks. So we got a problem. We got to do some boarding up, some patching up, and reconstruction. Yes, we got to do it. We got to be responsible for doing that. That's
Yes,
our
sir.
job. So that's why me and Abdullah sacrificed and did a contract course about showing people how to set up government. Everybody want to know how it goes, go back and read a government course. That's how you guys go back and read the seven, how many weeks? A 12-week course you have, Abdullah?
It's 12 weeks. It's on the Moroccan Post Media YouTube page. It's free. 12, there's a course. Moroccan Post Media YouTube page. This class, this will be uploaded tomorrow on Moroccan Post Media YouTube page.
So
Thank you,
remember
brother. I
that,
appreciate that, brother. Thank you.
but please, everybody hear me. I want you to hear this again. In nature, if you're hungry and you got a fishing rod or a net, you catch a fish. If you've been growing food, you got to pick the food. If you like meat, you got animals, you got to slaughter the animals. In order to do all this is a process. After you catch it, you got to process it, clean it, chop it up, and then cook it. It's a process. Same way this way. It's a process of thinking. That's all it comes down to. You can't beat nature. You got to, just like we got this way over a long period of time, ain't gonna come overnight. We got gradually get ourselves out of this and ask the God of heaven, or the Most High of the hierarchy, and the mother and father of the cosmos to make a way for us so we can what? We can get over this. And they will. They'll make a way for us because information here now for us to escape, for us to get out of this. They let information done because they made a way for us. That's it.
Amanda put the link on in the chat. The Moroccan Post Media YouTube page link is in the chat. Amanda, thank you, Amanda. All right, we have 13 minutes. Shem is rocking with us, man.
Yeah, I'm gonna say something before I go. Let me say this right here. See, a lot of us don't know when you talk to somebody, when you give them an address, you give them a domicile. That's the first thing of being able to contact you, and you give them a domicile. So I suggest everybody. I'm gonna get Abdullah how to create an address. I'm gonna write down a sample how everybody should create their own address in Morocco. So when they go actually where you live at, you give them that address, and now they can't find you. You see, you say trustee for the trust of so and so. Now, when they go out to send a subpoena or something, you got to be able to contact you. You say in care of post office suite, so they got to have somebody to where to go at to serve you. Because without service, remember, they in criminal, they're doing civil process. That's why they got personally serve you, the subpoena. See, I'm teaching you what they're doing. And you got to be able to say, listen, you
Is
can't
that the same as Is that the same as notice the agent is notice the principal?
Yup, absolutely, because they gotta serve you. Now,
Yes, sir.
if how you think the United States is serving everybody? They got an address scam, longitude, latitude. What you mean? They got set up. That's why they say a post office. A post office is what does with latitude and latitude. They drop off what mail, drop off certain mail through certain agencies and certain people dealing with what civil matter or criminal matters. So you got to create an app. I'm gonna give an app to do it next time. I'm gonna show you. You gonna put a copy up how you do an address scam in a post office suite. So you have a certain way to protect yourself.
Shem, we got one more question.
Yes, go ahead. Go ahead.
Just adding on to this question as it relates to treaty rights. So one of the things that I talk about is a will. As a Moor, right? So let's say you got a will. Who do you deposit your will with? Do you, since we ain't got the government erected, who do you deposit your will so that they can protect the rights of the children when you file the will? You don't post to file it at the probate court. That gives them, they automatically take you out of your Moorish political status.
Okay, now I'm glad you said it. What you do, you don't create a will, you create a trust. You take all the property, assets, commodities, newlies, and put it as collateral of the trust, and put down your trustee, and then you put down who the beneficiary of the trust. So now it's a living trust. So you take the trust and invest in the trust down there. So that way, when you die, your property don't go on probate, or no attorney can take over your property as a conservative. So now what you do is you put your property in the proper jurisdiction, the trust, the proper jurisdiction, you put the property as an asset, schedule of the trust. Now, all the beneficiaries in the trust, when you die, nobody can take your property, all your newlies, your assets, your money, your wealth, goes to your beneficiary, and you got the trustee already set up on the trust. The only one that operate the trust is the trustees. That's why when you go to court, when they lock you up, because attorneys are the trustees of the state. They handle state property. So the state, you are the beneficiary, but you are incapacitated. You consider as a ward, incapacitated person. You ain't supposed to be doing in the courtroom speaking. You don't know who you are. You call you incapacitated, a moron. You don't know nothing. So the attorney is the one as the trustee for the trust. You is a beneficiary. The collateral of the trust is your body. So the attorneys in the court will represent your body as what? As collateral for the state. You understand?
So let me ask you. So, because this is an element that I'm understanding and bringing to the attention. So do you take it to the probate court and file the trust?
No, you take it to the rest of their wills.
So I'm saying, where do you, somebody got to hold it as the custodian of the records.
That's in the rest of their wills. In most courts, a lot of rich people going out to register wills, their attorney file a will. The Rothschild, J.B. Morgan, they file a trust. They don't file a will because they file a will, the state officers take over the assets as conservative. So they file a will. A trust. That way the trustees control everything. That way if you die, the state can come in and tax your estate. It can't tax nothing because it's in a will, it's in a trust.
Okay, so you filed the trust.
Yes.
Could we use that trust as evidence once they deposited? I'm just saying
No. On the trust law, when you use the International Trust Act, see, this is why I say it's very important to have a government set up, or a group that you set up outright as a civil society organization. That way, that group have a certain judge consultant that operates for you to use the International Trust Act to protect your assets. All the United States, everybody sign on to an international agreement under the Trust Act, the International Trust Act, protecting all nationalities and property. Therefore, the judge consultant will contract coming in and say, well, it's trust property. The state already knows there's a trust. They don't have jurisdiction. They can't tax. They won't tax it.
No, this is what I'm saying. Okay, so because a lot of Moors are doing this, they want to put all their property in the trust, right? They want to put their car, their house, all of these different things in the trust. So once it's in the trust, okay, and you have a trustee, right, under the International Trust Act.
That's for status. Let's say if you do a status. You got, first of all, you're a status as you're more about consanguinity, but political status, you're a United States citizen. That means you permanently reside in the United States political jurisdiction. So therefore, you yourself, the trustee, is what? A ward of the state. Why? Because you don't have a government that's already said, you don't have a passport or ID saying that you part of a Moorish government and that government can vouch that you are that, and you have a proper passport and document like a certificate of consanguinity. All this come in play. All this status, everything before the law. Order for the course, or anybody that take jurisdiction, is they look at, first of all, look at the seal that the trust got, who signed it, who signed the document, and my capacity as what. And you attach your documents, your Moorish documents, and first of all, it's already filed in your government, your state. It's filed and stamped by the consul office, and as the law becomes conservative now. He goes to file in there as a document record, as a notice that this property in your political jurisdiction belongs to a Moor and protected in international law. That's how it's done. That's why I say the best way to get over this hump and not have a problem no more down the line is to government. That's it.
So how do we go about appointing someone to delegate those duties on this side?
I'll do the shit. Go to the government courses, study that. You see how to
Okay,
play the
cool.
government from.
Yes, sir.
All right. Shem rolled with it, man. Shem was with us, man. Shem usually signs off at 9 o'clock. He's with us, he's with us the whole time, brother. Appreciate it, brother.
All right, that's the last question, Joe.
Thank you for
think about that. Go back and watch the government
We
course.
got,
And
we got one more question, Shem. We got Paige. Shem, answer this last question, Sister Paige.
Oh.
Paige.
Oh yeah, thank you all so much. I was just gonna ask you, Abdullah, is it I know that you said that you all were coming up with the next class, or I'm sorry, the next cohort, shall I say, next year. And these classes that we did were the prerequisites to those classes. Do you all have a definitive date by any chance?
Are you talking about the Shem? She's talking about the advanced class that you're gonna be teaching. No, we don't have a date yet. We might have to push it to June because we're looking. Yeah, it's gonna be. Shem, we're gonna have to teach that on a Saturday, Shem.
Mm-hmm.
So I gotta work out some particular with Shem and Terrence. So let me work out these particular with Shem and Terrence, and so we can teach this. It's looking at about 7 weeks. It'll be about $200. And the prerequisites, you would have to be with us for about at least 4 to 6 months, as far as taking these classes and stuff. So it's going to be an advanced course. So let me work out with some particulars with Shem and Terrence.
Thank you so much.
All right.
All right, y'all.
All right, Shem. Thank you, brother.
Yes. Y'all take care, okay?
Yeah, we're
Thank you, Shem.
Yes. Appreciate y'all.
All right. So we're gonna have these samples, Shem. I got the sample of the Quo Warranto. We'll do that next in 2 weeks, the next class.
Okay.
The next class will be in 2 weeks. Give me the date for that, please. Somebody give me a date.
I think it's January 11th.
January 11th is the next class. Wednesday, January 11th, the next class. We're going to deal with the sample of the Writ of Quo Warranto. All right, that's part 3. And then we'll do that with the sample as well, and then we'll do a review. All right.
Okay.
With Writ of Quo Warranto. All right. So now that'll end the Writ of Quo Warranto section, and then we're looking at some doing affidavit and a complaint. But I'll talk to Shem about that.
Okay.
All right. So Shem. I'll talk to you tomorrow. So we're gonna close out, everyone. You got this class will be uploaded tomorrow. Terrence is gonna upload this class tomorrow. The Moroccan Post Media YouTube page. All right. And I will see y'all on January 11th at 7 p.m. Eastern Standard Time. I'm going to be on the Clubhouse on Saturday. I'll send that link out. I'm going to be on Clubhouse this Saturday at 2 p.m. I'll be on the Clubhouse. I'll send the link out to everybody. If I don't have your number, my number is 215-300-5471. You can text me 215-300-5471 for those whose numbers I don't have. Everybody, but I'll send out the Clubhouse link. I'll be on Clubhouse at 2:00 on Saturday. What the title is, what determines the new year? In fact, I did that on January 1st. Facebook took it down. Like I did it here for an hour and some change. Facebook took the only video that Facebook, I have all these videos I've done and breaking down Christmas and you name it, breaking this all this down. Facebook took that video down. They took that video down. What determines the new year? They took it down. So I'm going to be doing that on I'll be doing that on the Clubhouse. I'll send the link out. I have the link already. I already have the link. I'll send the link out tomorrow. All right.
What's that number yours?
215-300-5471. Just text me your name and I'll send you the Clubhouse link. I'll probably send it out on Friday. Yeah, Friday but I'll be live on Clubhouse at 2:00. What determines the new year? That's my next live. And then I will be live next week on Sister Freedom's. I'll send that link out next Wednesday. Next Wednesday at I think 8:00, I'll be live with Sister Freedom. She has a page. But I'll like I said, I'll keep everybody posted. I'll send out the link, the Clubhouse link for Saturday, and I'll send out the live link for next Wednesday night. And then I'm trying to get back with do a part 2 with Tahaka because I was down for the count. I was down for the count nursing this cold for the past week. All right, so I couldn't do part 2 with Tahaka. All right, I appreciate everybody. All right, next class January 11th at 7 p.m. Eastern Standard Time. This class and all the other classes, Moroccan Post Media YouTube page. All right, thank you. So I'll see y'all on Clubhouse this Saturday. Next Wednesday, Sister Freedoms. I'll send out the link. I'll be on Sister Freedoms page at 8:00 next Saturday. Next Wednesday. All right, and then we'll be back on this Zoom on Wednesday, January 11th at 7 p.m. Eastern Standard Time. Sister Kira and Brother Zach, thank you for filling in for Terrence. And
You're welcome.
Thank you. So Kira, you can end the recording. Thank you, everyone. Peace.
Islam.